With due consent, Your Lordship, I beg to mention items 40 to 43, Your Lordship. 44,
40.
41, 42, 43, 44. So can it be taken up after 3 weeks, Your Lordship?
Okay, you have informed the other
Yes,
side.
I also submitted the adjournment slip yesterday, Your Lordship.
Mr. Edas.
Yes, Your Lordship. I am in item 41 and 44.
41.
44.
Learned counsel for the petitioner in 41
And 44.
and 44.
I am for 40.
And Mr. R.J. Das, direct counsel for the petitioners in 40,
42 and
42 and 43 have sought adjournment of the cases for 3 weeks. It is submitted by the learned counsel for the parties petitioners that counsel has been taken from the learned counsel for the respondents, and a mention memo to that effect was also circulated yesterday. So in view of the prayer, the joint prayer meet. So meet, is allowed. Release the cases after 3 weeks.
So interim order to continue,
By the office.
Interim orders to continue, Your Lordship.
Okay, interim order, file, interim order. Past earlier shall continue
Much obliged, Your Lordship.
till the next date of listening.
Much obliged.
May I please oblige? My lord, I beg to mention item number 30, my lord. Here, my lord, we have to file one additional affidavit, my lord, bringing about the report of DTO, my lord. So I pray, my lord, matter be listed any day next week, my lord, so as to enable me to file affidavit.
Week commencing 29th, right?
My lord.
Mr. G.I. Borgmia, learned counsel for the petitioner, has prayed for listing of the case after a week in order to enable him to file an additional affidavit to bring subsequent developments on record. It is submitted that consent has been taken from the learned counsel for the respondents to make the prayer. The prayer is allowed. Release the case on a date
Second,
to be
third,
fixed
any
by
day.
the office in the week commencing 29th, 29/1,
Any date may be fixed.
2024. But we will fix. If I go on fixing, someday it will be 100, someday it will be 20.
May I please, Your Lord.
No.
So for item number 57 is concerned, Lordship. Can it be taken up at 2 because of my bank account has been freezed and I am not getting the salary for the last 7 months, Lordship.
It will wait. Decline at this stage. Yes.
May I please, your lordship? My lord, I beg to mention for listing of an admission item, my lord. Next week, any date, urgency?
What is the urgency?
My lord, we have prayed for demarcation of my land, my lord, under this Public Services Act of 2012, my lord. My lordship was also pleased to direct the authorities to produce the records, my lord, or to give personal appearance, my lord. Matter has been listed thrice, my lord, but could not be taken up. On next week.
We'll see.
May I please, Your Lordship?
All right.
My lord, I have filed a writ petition today morning, this morning, Lordship. My lord, regarding eviction. Eviction will be conducted tomorrow and day after tomorrow, 20th and 21st. My lord, may I pray for listing the matter today, Lordship? Eviction.
Okay. If time permits.
Obliged, Lordship.
Wait, please, Your Lordship. I beg to mention item number 50 with the consent of the
Item number
50, Lordship, 50.
5. Yes.
3 weeks time may be granted, Lordship. We need to file next.
Lordship, appeal for the petitioner, Lordship, the interim order may be continued.
Okay. 50. Mr. N. Gautam, learned counsel for the petitioner is present. MS S. Kemprai,
Lordship.
learned standing counsel. KAAC for the respondent number
2, 3, and 4.
224 has paid for and is granted 3 weeks time to file counter affidavit on behalf of the said respondents. Also, the interim order passed earlier. shall continue till the next.
Lordship, may I pray that in item number 25, Lordship, we have filed an affidavit in reply, Your Lordship.
Item number 20.
5 and 26, Your Lordship, we have filed an affidavit in reply. That may kindly be called for, Your Lord.
May it please, your Lordship. Lordship, I am praying for listing admission matter, my lord. Here, the NOK certificate is not issuing to the petitioner, so she is not getting pension, my lord, after death of her.
NOK is public service.
My lord, the DC is not issuing, my lord. He has applied, she has applied, so she is also not getting pension, my lord, family pension.
Then you should file before the Board of Revenue or Administrative Tribunal. That is the Board of Revenue.
No, my lord, admission stage matter is in admission stage.
Make an application before the registration. It is not such an urgent matter. Yes.
May I please, your lordship, I beg to mention item number 27, lordship. Actually, we have took dusty service, but due to vacation, it could not be completed, lordship. So kindly matter may be fixed. after
Okay, we'll
2
see at whenever it reaches.
Obliged, lordship.
Please, your lordship. Lordship, with the consent of the other side, I beg to mention item number 6. Your lordship, as per last order, I was directed to take instruction from my client, but we have not received the complete instruction. I have already informed the other side, so matter may be posted after.
Yes, Mr. Goswami.
My lord.
When? Next week?
After 3 weeks, lordship, because
After 3 weeks?
learned senior
Then we
counsel.
should notice then.
That
Cannot keep on
Yes.
getting listed in motion column. Mr.
F for it, lord.
F. Poridi, heard Mr. F. Poridi, learned counsel for the petition, and Mr. B. Goswami. Let it reach then. Let it reach, we'll issue notice.
Wait, please, lordship. Lordship, kindly list a matter, lordship. Any date after weeks, lordship.
What list?
Lordship listing for lordship. Yes,
What is the subject?
lordship. Subject matter is that lordship. Petitioner NOC, lordship, for NOC. Applied for NOC for gift deed, lordship.
NOC for?
Gift deed, lordship.
Give deed.
Yes, lordship. But that NOC has not been provided, lordship. So,
No agency.
lordship, pleading has been completed, lordship.
We'll
Affidavit.
see. Make an application before registry.
For motion item number 1,
Lordship, matter may be fixed on second half, lordship.
Motion, okay.
Marks with lordship.
item number 2,
Yes, it was adjourned earlier. When?
Yes, those similarly, those type, earlier also, my lord, your lordship has issued notice, this kind of cases, my lord. That to be, names to be recorded in the name of Hotian holder, my lord.
Have you submitted any application under Bosundhara?
Yes, my lord.
Who is it?
Application means what, that representation they have submitted, my lord. The another 3. Now they are not considering all these things because
This may
now
not be treated as an application under Bosundhara. Because under Bosundhara, it has to be online application.
no, but yes, my it is not treated, my lord. Now the thing is that, my lord, they are not considering it because as per this, if the land is, my lord, taken by the government also, even though the name of Khotiandar should be recorded, only that is the prayer.
Heard, Mr. Yes, Mr. Sharma?
Earlier also, your lordship issued notice, similar cases.
What is the court period required, Mr. Sinha or Mr. Sharma? For 13 number of petitioners?
13 number of petitioners, so far my knowledge goes most probably 60 rupees per petitioner.
Huh?
62.
58 हुआ part है.
How much?
58 part है, I think.
50?
58 part है.
Means almost 60. 16 to 13, how much?
600 সয়তিনি উঠৰ
700 something.
780
780.
Lesser court fee.
Registry, yet I do not know. If they can object, why not? Registry can,
Heard. Mr. B. Sinha, learned counsel for the petitioners. MS Z. Hajorika, learned standing counsel, Revenue and Disaster Management Department for the response number 1.
let my learned friend be there, Lord.
MS M. Mormon, learned junior government advocate Assam for the response number 2 and 3. Full stop. The petitioners, comma, 13 in number, comma, have claimed it their predecessors in interest were holding an area of land measuring 11.66 acres within bracket 35 bighas under taluk number 15691 stroke 104 as under Khotian number 61 under one Muhammad Kabir, and the said area of land is covered by DAG number 218 within bracket old stroke 207 within bracket 9 situated at Molja Khagail PH Agor Sati, comma district Karimganj. Full stop. According to petitioners, comma, after the predecessors, the petitioners are in occupation of the said area of land by paying revenue to the state respondents. Full stop. Claiming that their name should be recorded in the revenue record. They have preferred the instant petition on the ground that despite submission of an application on 18/3/2023 to that effect, the respondent authorities are not taking any steps for recording the names of the petitioners. Also, issue notice returnable in 4 weeks. As MS Hajorika, Standing Counsel, Revenue and Disaster Management Department, has appeared and accepted notice on behalf of 1 MS Bormon, Junior Government Advocate, for 2 and 3, no formal notice. Extra copies within 3 working days.
Public. Item number 3.
May I please, your lordship? My lordship, this petition, my lordship, very small prayer I have made, my lordship. I have a land which was allotted to me by under Ramadhan Act, my lordship. On a particular date, my lordship, the authorities under the National Highway Authority, my lordship, declared some trees and some shrub from my land, my lord. So in this regard, I have filed a petition before the Deputy Commissioner, my lordship. The presentation is at page 12, my lordship. Kindly see, my lordship. Page 12, my lord, can you see? Annexure 1, my lord. My only prayer is that, my lordship, the deputy commissioner has not considered my prayer, my lordship, and they have kept the representation in abeyance, my lord.
Where is your land document?
My lordship, I have annexed, my lordship, annexed to my lordship, Jamabandi for surveyed village, my lordship. Annexed 12, page 14 is the type copy, and page 15 is the,
How much land in Dag number 424?
my lordship. In
Your particular one is very illegible.
Yes, my lordship, I have typed, my lordship. And receipt also I have annexed, my lordship. Page 17 is the receipt which I am.
Receipt is for 423.
Yes.
Jamabandi is for Dag number 424.
Both the receipt for 423 and 424, both the receipt I have annexed, my lordship.
424.
Annex, page 19 is the receipt for 424.
No, what, for what or who has acquired your land?
No, my lordship, I have approached before the concerned office to know whether my land has been acquired or not. And I have been informed that the land which they have cleared.
So you do not know that who has acquired your land?
My lord,
Under what
that
process?
land has not been
So
acquired.
you are asked to the High Court.
My lordship, I have filed representation before the deputy commissioner that on what basis my land has been cleared by the National Highway Authority, my lordship. Because that has been allotted to me by the under Gramadan Act.
Petitioner has not been able to throw any light.
But I have filed another additional affidavit also.
Nothing is there. Nothing is there.
My lordship, the
Court has asked you to submit an additional affidavit, you will just have submitted an affidavit without any details,
I'm
making that unknown persons.
My lord, that,
Lordship, there should be a 3A notification at least to indicate
These
what.
are bereft of any detail
my lord, I'm going
to
to office to know on what basis my land.
reach a view that there is a cause of action.
My lordship, I am going from office to office to know on what basis my land has been cleared by the engaged labor under National Highway Authority, my lord. Without finding any option, I have filed a representation
National
before
Highway,
the
there is nothing.
before the deputy commissioner.
So be the notification at least, if National Highway Authority is involved, it must be preceded by notification under
They are
3A.
they are working, my lordship, to
3A.
identify
National Highway Authority do not act without any notification.
It's only, my lordship, from office to office, I am going, my
So-
lord, to know on what basis my land has been.
Find
cleared.
an application under RTI. We are not here for give you information.
Fine.
Asking to the deputy commissioner, please provide the information.
No,
If you want to have information, please
my only prayer is.
have the, no, please have the information for RTI Act. Even if it is really your land has been acquired or some other person has entered into your land. Otherwise, we are,
My lord,
otherwise,
my
it
prayer in the
appears-
writ petition is the deputy commissioner.
No,
the
we will not-
representation may.
will not burden the deputy commissioner without any effort from the petitioner.
Some more time maybe. to
No.
my lord.
You better file an application before the appropriate authority under RTI, get the information and come. This is not the way, Mr. Oscar, to approach a constitutional court,
Yes, my lord.
to get information, as if it is a counter.
No.
You file an application for information and we will provide the information.
No.
There are many avenues to get the information. If it is NHAI, there will be definitely a notification under 3A,
Yes, my lord.
under the National Highways Act.
In the representation, my
Or-
lordship,
It must
some
be
of the
preceded-
information has been written in representation, my lord.
Nothing.
Annexure 1.
We are afraid, Mr. Bhaskar,
Hmm.
we are bereft of any detail
Hmm.
to reach any privacy view that there is a cause of action for you to maintain a reputation. Better you get the information than come. If your land is is taken over, definitely you will be entitled.
Yes, my
But
lord.
get the minimum information, Mr.
That is, I accept, my lordship. That is repeated.
Then I am dismissing them.
Better I will withdraw and maybe liberty to get.
It is up to you.
Yes, my lord. File again after getting relevant information.
Definitely, there can be cause of action. Mr. S.B. Loskar,
Yes, ma'am.
learned counsel for the petitioner, has submitted that the petitioner seeks leave to withdraw the petition with the liberty to approach again. Mr. I. Bota,
Respondent 5.
okay, who is for revenue? Z. Hajorika, standing counsel revenue 1.
I appear for respondent number 3.
PWD, B. Chaudhuri, standing counsel PWD 2. 3.
T. Bora.
D. Bora, standing counsel.
Not on behalf of Mrs. R. Bora.
Okay. Learned counsel appearing for MS R. Bora, standing counsel NHAI. Mr. H. Sharma, learned additional senior government advocate for the respondent number 4, and Mr. I. Bora, learned standing counsel Forest Department for the respondent number 5. So, in view of the above submission made by Mr. Loskar, learned counsel for the petitioner, the petition is dismissed on withdrawal with the liberty as per.
Highly observant.
Same, my lord. Only Khotian number is 102 here. Other everything is same.
আগৰো লিখি দিব the office is to ascertain about the sufficiency of court case. আগৰটো লিখি দিব এইটো how many 10
Here, my
here also
11, my lord.
doubtful
11.
11, huh? Dark numbers are same.
Same, no, documents are different.
Okay.
238 O and
আগৰটো
118
চাই
new.
ল'ব পাৰিব আগৰটো কিমান 35 আছিল তো 16 বিঘা ইয়াতে 6.09 একাৰ তালুকটো চেঞ্জ হ'ব আন্ডাৰ মোহাম্মদ কাবিৰ
Yes, my lord. They say same taluk.
খাটিয়ান নাম্বাৰ চেঞ্জ হ'ব ডাক নাম্বাৰ পাট্টা নাম্বাৰ চেঞ্জ হ'ব বাকীখিনি এপ্লিকেশ্যন ডেট 18/3 চিনপচিছ চাই ল'লে হ'ল চেম কোড ফি
The matter really is disconnection of water connection, madam, by GMC, madam. The Lordship asked them to take some.
No, DMC has not disconnected it. Maybe because of some infrastructure work is going on that has been disconnected. But after inquiry, it has found that there are some due, my lord. We will approach it, pay the due, it will be connected, my lord. We'll do the work required, my lord. All the disconnection done by some other infrastructure works. Other infrastructure work is going on parallelly. So that has led to the disconnection, not by the action of the GMC.
Other development work.
Yes, there are some other PWD is doing some roadside work and other agency also doing work. Gas connection works is going on.
So if it got disconnected, who is the responsible authority to get it connected?
That is the GMC. It's a GMC water has disconnected. At the same time, my lord, he has some dues to pay to GMC.
I am ready for that,
He is
madam. I have
ready to
already.
pay and he will pay, and in the meantime, we will do the restoration work.
Binu to Diok will dispose of electricity. Relief. We dispose of.
Lots.
Because like electricity, this is
Yes.
Yes, essential
That's
service,
a still violation of Article 3.
Heard Mr. S. Mukhtar, learned counsel for the petitioner, and Mr. S. Bora, learned standing counsel, Municipal Administration Department.
No, my lord. I am only for respond number.
Okay. H. Sharma, learned additional senior government advocate. Assam for response number 1. And Mr. S. Bora, learned standing counsel GMC for the response number 2. Close. We're not saying that he's a lawyer.
Lord.
The petitioner has asserted that he entered into a rental agreement on 31/12/1996 with his paternal uncle, Jyotish Chandra Burman, for letting out a one RCC building measuring around 700 square feet. Petitioner, a practicing lawyer, 700 square feet on monthly rental basis for the chamber of the petitioner. So it has the premises, rental premises spots. The rental premises had electricity connection, and also had a regular water supply connection, provided by the respondent GMC. The petitioner, according to the petitioner, has further asserted that he has been using the said rental premises as his chamber till date. Said rental premises, having GMC holding number 104 within bracket house number 26A bracket close, till date.
Place may be mentioned, my lord. Place may be mentioned, AK Azad Road, my lord. AK Azad Road, Rihavari, Guwahati, my lord. AK Azad Road, Rihavari, Guwahati.
The petitioner has further stated that the said rental premises is standing on a plot of land covered by tag number 129 and KP Patta number 76 at Sohor Ulubari, Part 1, Mauja Ulubari, and on AK Azad Road, Rihavari, Guwahati. So the petitioner has further claimed that by executing a will on 30/12/1997, the petitioner by executing a will, his uncle, Jyotish Chandra Burman, as the owner of the property, had executed a will in respect of his properties, which included the rental premises as well. He expired?
Yes, yes, ma'am.
When?
13/5/20.
Okay.
13/5/15, my lord.
When? From 2009 onwards. Jyotish Chandra Burman started suffering from illness, it was the petition who used to who looked after him. On 13/5/2015, the petitioner's uncle, Jyotish Chandra Burman, had expired. So subsequent to death of the petitioner's uncle, i.e. the owner of the rental premises, dispute started to erode. Dispute started arising between the family members of the deceased. But during till date, the petitioner is in occupation of the rental premises. Post. The petitioner has alleged that which month,
My lord.
all on a sudden,
22, my lord. Beginning of 22.
all on a sudden petitioner has alleged that in the year 2022, all on a sudden, the water supply connection to the rental premises stood disconnected. A number of representations were filed by the petitioner before the respondent ZMC authorities with a request to allow the petitioner to pay the property tax in respect of the rental premises.
And to restore the connection.
And to restore the electricity connection,
Water connection.
water supply connection to the rental premises. Full stop. Mr. Bora, standing now. Was asked to obtain instruction as regards the region behind disconnection of the water supply connection to the said rental premises. Post of Mr. Bora, standing of ZMC, has submitted, on instruction, had submitted on 5/1/2024 that a technical team of the ZMC would make an inspection of the rental premises to find out the reason for non-supply of water to the said rental premises. Post of today, Mr. Bora has submitted that a number of development works are being undertaken by other departmental authorities like PWD,
Gas agency.
gas, PWD,
Gas now.
etc. He has further works are also being undertaken. Works are also being undertaken for supply by different agencies for supply of gases
Gases.
to the households in the vicinity. Full stop. From the projections made, comma, it appears that the petitioner, being a nephew of the owner of the owner, within bracket, since this of the rental premises, has some bona fide claim in respect of the rental premises. Full stop. It is not a case of the respondent that the petitioner is in unauthorized occupation of the said rental premises. Full stop. Though the matters of title and ownership of the rental premises maybe can be subject matter of dispute, comma, from the assertion made by the petitioner, it appears that he is in continuous occupation of the said rental premises pursuant to a rental agreement executed by him with the owner since this is on 31/12/1996. Stop. Para. It has been the Honorable Supreme Court of India in criminal appeal number 810 stroke 222 within bracket Dilip within bracket date through LRS versus Stotis and others bracket post comma decided on 13/5/2022 has observed in connection with has observed in respect of electric connection that electricity is a basic amenity from which a person cannot be deprived of. Full stop. It has been further observed that electricity cannot be declined to a tenant on the ground of failure stroke refusal of the landlord to issue no objection certificate. Full stop. It has been emphasized that all that the electricity supply authorities are required to examine as to whether the applicant for electricity connection is in occupation of the premises in question. Full stop. By the same analogy, comma, the supply of water to a household can be considered to be basic amenity from which a household should not be deprived of unless such disconnection is made due to default on the part of the such household. Full stop. As the petitioner has claimed to enter in occupation of the said rental premises pursuant to execution of a rental agreement on 31/12/1996 with the owner since this is of the rental property and has further claimed that he is in continuous occupation of the said rented premises till date. Comma. The court is of the considered view that the water supply connection to the said rental premises, which is stated to be disconnected, comma, should be restored immediately. Full stop. The respondent GMC authorities shall ascertain as to whether any dues are pending in respect of the concerned water supply connection to the rental premises. And if any such dues are pending, comma, the same shall be intimated to the petitioner for payment within a period of 2 weeks. Full stop. If such intimation is provided to the petitioner shall deposit
Within 1 week.
the dues within 1 week thereafter
Right.
to the respondent GMC authorities. And on such deposit, the respondent authorities, the GMC authorities shall restore the water supply connection
Immediately.
to the said rental premises within a period of 1 week thereafter. Full stop. Notwithstanding, the development works undertaken by the other departmental authorities in the vicinity. Full stop. It is further observed that the payment, any payment of any outstanding areas in respect of the rental premises by no stretch shall by payment of any outstanding dues in respect of the water supply connection in respect of the rental premises shall not accrue any right to the petitioner in respect of to claim any kind of title or ownership in respect of the rental property. At any time. This order disposes of the writ. Here, something was made.
My lord, in fact, the issue has already been resolved, my lord. In presence of the petitioner, my lord, everything was done.
Then why it needs 3 weeks time?
My lordship can.
We have, because of your urgency, you have taken up
Yes, Your Honor.
on a faster basis. If matter
Everything
has
was
been resolved,
in presence of petitioner also. Conducted survey twice.
what do you say? This has been amicably stated to be resolved, including the petitioner.
Next week, in any day.
Take instruction, why you should keep pending if you have arrived at a settlement,
Yes, Lord.
then we should not keep this petition pending.
Any next.
And there is a
next week-
statement that they are going to acquire 4.5 lessons.
Yes.
If it is, and the four-legged
Yes.
tower
Yes.
2 lakes would be on government land, 2 lakes on your land.
Lordship. Lordship, I'll take instruction next week.
Not now in the middle of the,
Actually, because of this the petitioner already went to the office to seek instruction regarding this thing. I have already provided him the
this
last.
is on 17 January also.
Yes, but he have not.
He was there on joint survey on 4 January and on 17 January. We are on 19 January.
Yes, Lordship. The 17 January yesterday also I have spoken to him. He told I was not present there. I don't know. I have to seek instruction any date. Next week.
See, if he is present, thereafter he is saying not present and delaying the matter will not.
Next week, any date. Lordship.
Okay. Mr. Mr. F. Faridi, Learned Counsel for the petitioner, and Mr. B. Goswami, Learned Additional Advocate General Assam, assisted by Mr. S. Borwa, Learned Counsel for the respondents. Mr. Goswami has placed a communication bearing number so and so dated 18/1/2024 of the additional Deputy Commissioner Kamrup, wherefrom it transpires that a joint survey was undertaken on 2 dates, 4/1/2024 and 17/1/2024, for installation of AEGCL tower in presence of PWRD officials, in presence of officials of the PWRD, AEGCL and the petitioner, number 1. Along with the staff from the revenue, North Guwahati Revenue Circle. Full stop. As per the said communication, it has been decided between the parties that 2 out of the 4 lakes of the tower would be relocated to the land bearing DAG number 293, owned by the petitioners, and the remaining 2 lakes would be shifted to the adjacent government land bearing DAG number 292. Mr. Faridi, Learned Counsel for the petitioner, who has been furnished with the said communication, has sought for a week's time, sought for 3 days' time to obtain instructions and further instructions from his clients. Release the case on 29/1.
Item 7.
May please, your lordship.
What is the order?
Page number 10, lordship.
From serially. Third, Mr. DKD, Learned Counsel for the petition, alleging non-compliance of the direction given by this court in an order dated 28/11/2022, passed in a petition WPC number 5168/2017. The petition has approached this court by instituting the instant contempt application. The petitioner has averred that the order dated 28/11/2022 was duly brought to the notice of the alleged condemner. Issue notice, return it in courts. The petitioner shall take stage for service of notice upon the sole respondent by registered post within 3 working days.
Obligation.
Number 8.
May I please?
What is the order?
My lord, the order your lordship will find, my lord, at page 43, annexure 11.
Is 40.
My lord, operative part, my lord, page 45, paragraph number 4.
45.
May I read, my lord? Upon hearing the learned additional senior advocate as well as the learned standing counsel of the revenue department, the court is of the considered opinion that instead of keeping the matter pending, it would be appropriate to issue a direction upon the respondent number.
Heard Mr. Bikason. Have you brought it to the knowledge of the
My lord, annexure 12,
next
page
12
46.
additional deputy?
Respond number 3.
Yes.
Okay. Heard Mr. Bikason. Learned counsel for the petition. Full stop. The petitioner has stated that he had earlier approached. He had submitted an application for cancellation of the name of the purchaser of a purchaser from the revenue records and to restore the name of the petitioner in respect of a plot of land. Full stop. That resulted into the said application resulted into a proceedings registered as ARC within bracket capital M stroke 302 stroke 2020, and notices were issued to the concerned stakeholders for hearings. Post of when no progress in respect of proceedings. As stating that no progress was made in respect of proceedings of RC so and so, the petitioner prepared a writ petition, WBC number 3275/2023. Of the said writ petition, WBC number so and so, was disposed of by an order dated 9/6/2023 with a direction to the respondent number 3 therein, i.e. the sole respondent herein. Mr. Sen, only respondent number 3.
My lord, notices will go, my lord, against only.
No, no,
respondent
Lord.
Number 3, my lord.
No.
Because, my lord, they are
No.
the superior officer of the respondent number 3, my lord.
Then he may say that they are not doing, that is a different thing.
My lord.
Will not embrace all this, include all these other 3. Why Commissioner and Secretary?
No, my lord.
Revenue Department.
No need to.
No
issue
need.
Notice, my lord.
The direction is very specific.
Yes, my lord. Respondent number 3.
Then-
That is true. My lord,
Don't try
one,
to.
1 and 2 may kindly be strike off, my lord. No need, my lord. In fact, it is inadvertently, my lord, given.
To the respondent number 3 therein. Also the respondent number, also the alleged content number 3 hearing. To take up the adjudication of the proceedings of RCM stroke 302 stroke 2020. If required on a day-to-day basis, and to dispose of the proceedings preferably within an outer period of 3 months from the date of receipt of a certified copy of the order. Post of the petitioner has asserted that a copy of the order dated 9/6/2023 Supra was duly brought to the notice of the alias container number 3 on 13/6/2023 within bracket and X circle. Full stop. Though alleging non-compliance of the same direction, the petitioner has preferred the instant contempt petition under section 12 of the Contempt of Courts Act 1971, read with Article 215 of the Constitution of India and contempt of so and so, so and so. Full stop. As though the petitioner has implemented a number of authorities or persons as respondents in the instant contempt petition, this court, considering that specific direction was made, by order dated 9/6/2023, only to the respondent number 3, implemented hearing, there is no necessity is found to issue notice to the respondent number 1, the respondent number 2, and the respondent number 4, party respondent number, implemented hearing. Let notice be issued only to the respondent number 3. Notice is made returnable in 4 weeks. A petitioner shall take steps for service of notice by registered post upon respondent number 3 by registered post with AD. Full stop. The petitioner shall also take appropriate steps for deletion of the names of the respondent, party respondent 1, party respondent number 2, and party respondent number 4 by way of additional pleadings.
Highly obliged.
Item number 9.
May I please, Your Lordship? Lordship order dated 01/09/2023, Your Lordship. Passing WPC number 05 5023 24 and 2023, Your Lordship. And Your Lordship, operative part at page 10, Your Lordship. Paragraph number 5, Your Lordship.
Okay. Heard Mr. S.I. Akon, Learning Council Board application. You have brought the notice, the order to the notice of the
Yes, Lordship. Respondent number
sole respondent. Commissioner. Alleging non-compliance of the direction made given in an order dated 1/9/2023, passed in a writ petition WPC number 5024/2023. The petition has prepared the instant contempt petition under section 7 cross title issue notice returnable in 4 weeks. The petitioner shall take steps for service of notice upon the responsible respondent by registered post with AD within 3 working days.
Item 10.
May I please, the Lordship. Lordship case 9, Lordship order. And 11 case Lordship 11. Lordship.
11. Yes, it was filed earlier. Also?
Yes, Lordship. That is,
Ah.
yes, withdrawn, Lordship.
Now, have you brought this order to the notice of the newly implemented
Lordship, so per,
respond number, sorry, newly implemented, respond number 1?
Lordship,
When did he join?
Lordship, I do not know, Lordship. As because, Lordship, whatever direction has been.
Because the space, because that I remember now.
Yes, Lordship. Lordship,
You made somebody who was not in the office of the deputy commissioner.
Lordship, kindly come into page 12, Lordship.
I have seen it.
Lordship, Lordship, whatever representation, Lordship, I have submitted on that
No,
office, Lordship.
no, mister. This is not the way. I made the specific observation.
Yes.
Though did not record it. It's new incumbent joined. It should be brought to the his notice. You served the notice upon him. Other one who got transferred long back.
Yes, Lordship.
That is not the procedure.
Lordship, office.
No, mister. No, we will not permit this kind of petition. Heard, Mr. I hope. Learning concept of petition.
Lordship, one thing, Lordship. Right. Can Lordship, this matter may be adjourned?
No, we will not do. No, we will not do all this piecemeal basis. The petitioner had earlier preferred a contempt petition from our contempt case C number 714/2023, alleging non-compliance of the direction given in an order dated 11/8/2023. Passed in a writ petition, WBC number 7851/2022. Full stop. Why you have not annexed the copy of the order?
Lordship, on that day.
To mislead the court?
No, Lordship. That order was
To
not.
mislead the court or what?
No, Lordship, I have made
So
a
that it escapes the notice of the court.
No, Lordship, I have made this statement.
Made a statement.
Yes, Lordship, as because Lordship.
Court is not going to read every statement.
Lordship.
Court generally looks at the annexer.
Lordship, on that day, Lordship, I has not made order copy online, so that's why, Lordship, I have made a statement, Lordship.
This is not appreciated, this kind of.
Lordship.
The said contempt petition. Contempt case C number 714/2023. Was allowed to withdraw as the petitioner, at that point of time, did not make the then incumbent deputy commissioner, district commissioner, Kamrup Metro, as a party respondent. No, had made the previous district commissioner, Kamrup Metro, as a party respondent. Full stop. As the incumbent district commissioner, Kamrup Metro, was not made a party respondent in contempt case C number 714/2023. The petitioner was allowed to withdraw the petition or contempt petition with the liberty to file FS by an order dated 8/1/2024. Full stop. With the withdrawal of the said contempt petition, it was incumbent upon the petitioner to bring the notice, bring the order dated 11/8/2023, Supra, to the notice of the present incumbent, to the notice of the incumbent, District Commissioner Kamru Petro, who has recently joined. Who has joined. After 16/8/2023, so the petitioner hearing has annexed a representation dated 16/8/2023 as annexed B to the contempt petition. Full stop. Does it clearly transfers that the order dated 11/8/2023 has not been brought to the notice of the present incumbent District Commissioner Kamru Petro, who has been implemented as party respondent one in the contempt petition, present contempt petition. Full stop. In such view of the matter, the court is not inclined to entertain this contempt petition. Full stop. Liberty, however, stands reserved to the petition to file a press after due compliance of the formalities.
Highly appreciated.
The petition in this case is challenging an order passed by the assessing authority rejecting the claim of the refund of the interest.
Page?
My lord, that will also find 66, my lord.
60.
But I may just give a brief, my lord. My lord, prior to that, my lord, the interest was levied and interest was levied for the assessment year, my lord. The petitioner approached this honorable court and a division bench of this honorable court held that, my lord, if there is no demand as per the demand notice, interest cannot be levied. And thereby the interest which was levied was set aside. Now the matter was carried to the Supreme Court by way of SLP. Now the SLP was dismissed with an observation that the tax which was directed by the Supreme Court to be paid earlier, in earlier proceedings, should be paid with the interest as statutorily leviable. Now, we said, that the division bench of this honorable court already by examining the provisions of the act has held that no interest is leviable, and thereby, since there is no interest statutorily leviable, the Supreme Court has upheld the order of this honorable court by rejecting the SLP. As such, the interest is not leviable, and thereby the interest which was paid in excess should be refunded. Now, what the assessing authority has done, he has again examined the provisions of the act, which was examined by this honorable court, division bench. And by examining the same, he said that no interest will be leviable. Now, the question is that, my lord, when this honorable court, the division bench, has already examined the provisions of the act and has held that interest is not leviable when there is no demand as per the demand notice, and the apex court dismissed the SLP and only said that, my lord, the tax amount should be paid along with the interest as statutorily leviable. Then, my lord, the earlier order of this honorable court, by which it was held that interest is not leviable statutorily, well, the department assessing authority has no right.
Where is the this court's order?
Well, this court's order you'll also find at page 41.
Page 40. Annexure 2.
Well, my lord, this is annexure 2.
This was filed against the
Well, earlier assessment.
directly, these are writ petitions.
This petition. Now, again,
Before division bench.
before division bench, well, earlier the tax matters were taken by the
Okay.
division bench. And then 52, you'll also may see page 52, the Supreme Court's order, my lord.
What is the events? Just to understand.
My lord.
The events which
Well, I mean, because prior to that also.
gave rise to that.
Well, I will tell you, Rossi, prior to that also, there is a lot of, well, the petitions and SLP were there. Well, earlier, there was a dispute that when the products which are purchased within locally, petroleum products,
You purchased petroleum products from BRPL
BRPL,
and resold the product in the state of Assam
Assam,
to your dealers.
through the dealers.
You collected surcharges from the dealers
Well, the surcharge was
for
collected.
payment to the central government.
Milo.
In his assessment, order found that PGM is liable to pay tax only on difference between the resale price and the purchase price.
Milo.
And the surcharge component collected on the sale price thus rejected the contention of petitioner's liability is only to pay tax for the difference of price collected from its dealer. Meaning thereby, you purchase petroleum products from BRPL.
At 100 rupees, Milo.
Say 100 rupees.
And I sell it at 140 rupees.
40 rupees. Okay.
Then I have to further pay on 40
No,
rupees.
to the dealers or to the
government.
ultimate consumer?
To the government, Milo. I have to pay the 40 rupees tax further to the government. Because while purchasing, it was a first point levy. So while purchasing the goods from BRPL, I paid on 100 rupees. BRPL paid on 100 rupees by collecting it. Now there was a provision that, Milo, if the price exceeds by 40%, if the difference between
No,
purchase
say
price-
140.
Milo.
140 you sell to the sell the petroleum product to the ultimate retail consumer.
Consumers.
Ultimate consumer.
Hello.
So in the
That's a-
process, there's 40 rupees.
40.
Say 40 rupees.
Milo.
Out of that 40 rupees what are the components within that 40 rupees?
Well, we submitted that there is a surcharge is there,
Surcharge.
which goes to the coffers of the.
Say 10 rupees surcharge.
Well, if 10 rupees surcharge is there,
Say
my lord, then if it comes to below 40%,
that 10 rupees is to be deposited with the central government.
central government,
So that remaining is 30%, 30 rupees.
30 rupees.
And out of 30 rupees, there will be profit.
Well, profit, etc., all things will be there.
And plus what?
Well, the question was that, my lord, if the resale price exceeds by 40%.
No, that is, I'll understand that later on.
There are various,
What are included in within say that 40 rupees?
mainly surcharge and the profit, my lord, and the
Charges and profit.
and the tax which was paid at the time of purchase of the goods.
You purchase it at 100 rupees
100 rupees, but I paid the taxes, my lord,
plus taxes.
plus taxes,
Plus taxes.
my lord,
So that tax will be deducted.
my lord.
Surcharge will be deducted.
The Supreme Court said that no, it will not be deducted.
No.
My lord, the Supreme Court said,
You say surcharge is to be deducted and it is to be deposited in the central government.
my lord,
Right?
my lord.
But on surcharge also something is to be paid.
The Supreme Court said that no surcharge, whether it goes to the central government or anywhere, it doesn't matter. You have collected the amount from the customers, so it becomes a part of the sale value.
Okay.
And thereby, my lord, because if the difference is more than 40%, then the tax was to be paid. And if it is less than 40%, the tax was not to be paid. By including the surcharge, it exceeded 40%. So the Supreme Court said that whatever the differential part is there, that is purchase price and sale price, like 100 rupees and 140 rupees, you have to pay tax on 40 rupees.
If it goes above 40 rupees.
But 40 rupees means 45 rupees it is there, then 45 rupees you have to pay.
Suppose it goes say 150.
150, 50 rupees you have to pay.
On 50 rupees you have to pay.
Earlier, this Honorable Court held that whatever was paid earlier, you forget, you have to again pay on the entire value. So against that, the company went to the Supreme Court, and Supreme Court said that no, there cannot be double taxation. He has already paid on 100, so you have to pay on the difference. Now, on the basis of that, my lord, prior to that, by a memorandum of understanding between the Government of India and Ministry of Petroleum, certain amounts were paid to the government, subject to the outcome of the, my lord, the SLP. Now, the Supreme Court set aside the orders of assessment with a direction to the assessing authority to verify whether the petitioner has collected any amount of tax from the customers on the entire value. Because if I've collected the entire value, then I cannot keep it. The assessing authority verified and said that no amount was collected by way of tax by the petitioner. The petitioner paid the tax on the differential part. Whatever differential part. Now, while making the assessment, the provisions of the Act said, my lord, that if, as per the remand notice, there is an amount payable, then after the expiry of 30 days, the interest will be payable. Now, as per the remand notice, there was no amount was payable, and thereby the interest was not payable. In spite of that, interest was levied. We went in appeal division, but after we not been successful, we came before this Honorable Court. And this Honorable Court said
that no, interest will not be leviable in case, as per the demand notice, no tax is payable.
Okay, where is that?
We'll also find. Yes. Well, page. I'll take it also, page 48. I take it also, para 6, after that,
Para 6.
para 6, in the
Say it aside.
cases in hand, the earlier assessment order and demand notices passed were set aside by the Supreme Court with a direction for the de novo assessment. And after de novo assessment, it is found that there is no demand for the assessment year. Therefore, the question of payment of interest on for the nil demand does not arise. Now, for 2 assessment years, my lord, the court found that from the demand notice itself, it is clear that there was no tax demand, and thereby set aside the interest demand. For the earlier balanced for the assessment years, the court remanded the matter to the assessing authority to find out whether there was any tax demand or not.
But in this specific case, there is no demand.
There is no demand
Okay.
in this case.
Ah.
Now, against it, my lord, the appeal was preferred before the Supreme Court, and you'll also find a page 52
By the state.
by the state. You'll also see page 52.
Not inclined to interpret.
Page 53 is important, my lord. The first paragraph.
Limited to liable to pay sales tax on the differential amount.
Along
You
with
say that the differential amount is nil.
differential amount we have already paid. The differential amount we have already paid. Now it says, my lord, along with interest as per statute. Now, our submission is that, my lord, this Honorable Court Division Bench has already held. As per the statute, interest is not payable. Now the apex court says that differential amount of the tax along with the interest as payable by the statute. And SLP has been dismissed against the Division Bench order. So, my lord, the interpretation made by this Honorable Court of the provisions of the Act that has attained the finality. And in respect of the same assessment here, the Division Bench has held that no interest is payable because there was no demand at the time of making the assessment. Now, when the matter, we filed a refund application before the assessing authority. there
So,
were-
according to you, this page 53, because of the memorandum of understanding,
My lord.
you deposited some amount. That has a relation with that division bench judgment, perhaps.
But yes,
They, because on de novo reassessment,
my lord,
there is found that no demand.
my lord.
So, meaning thereby, this differential amount it remains or it goes?
So after adjustment of the amount which we paid as per the memorandum of understanding, there was no demand. Now, as per the provisions of the Act, my lord, at the time of making the assessment, when the demand notice is issued, as per the demand notice, there is any tax payable and it is not paid within 30 days, then interest is leviable. Now, in our case, while making the reassessment as per the action of the apex court, the fresh demand notice was issued. And as per the demand notice, there was no tax payable, so the question of payment of interest does not arise. And that was upheld by division bench of this honorable court by interpreting the provisions of the act that no, interest will not be payable in case as per the demand notice, there is no tax. Now, the SLP which was preferred, this honorable court judgment has been upheld, has been affirmed. But Supreme Court only said.
Why this? Why this
Because
kind of proviso?
My proviso will say, the counsel who was appearing on behalf of the respondent, the appellant, sometimes they make a submission, one whether the tax that has been, as a precautionary measure, the tax should have been paid and all those things. The Supreme Court said that, okay, you have to pay the tax and the interest as payable by the statute. although they have dismissed the SLP.
Right, dismiss
So
that.
there was no necessity of, well, otherwise we would not have been there. If this proviso would not have been there, I would not have been there before your lordship again.
Right.
So, so the question is that, my lord, your lordship, that whether the Assistant Commissioner of Taxes can re-examine the section of the act to say that the interest will be payable. My lord, whether he can forget about the judgment of this honorable court. He is not considering the judgment of this honorable court. And he's considering again the section and says that interest will be payable. My lord, how it is permissible? At present, there is no demand, my lord. I'm praying for a notice only. Because
Yes.
Lordship notice may go and discuss.
Third, Dr. A. Sharaf, Lawyer Senior Counsel, assisted by Mr. P.K. Anand Datta, Learned Counsel for the petition, and Mr. B. Chaudhary, Learned Standing Counsel, Finance and Taxation.
All the rest.
Assam for all the respondents. A sale is made to an order dated 8/11/2023, passed by the respondent number 3. Whereby an application submitted by the petitioner for refund of a sum of rupees 26 crore, right? 26 crore.
my lord, I'm just
86 lakh 98,295 for the assessment year colon 1994-1995 on account of excess interest adjusted, comma, has been disposed of with a finding that the interest levied for the period for the assessment year colon 1994-1995 was on the delayed payment of tax due to the state as per the statutory provisions contained in Assam. What is the full form of
General Sales Tax Act.
General Sales Tax Act 1993. Full stop. The petitioner has contended. It has been contended by the petitioner side that a division bench of this court in its order dated 11/3/2015 within bracket. Which one is your passed in WBC number?
Well, WPC number I will give you.
1279/2008 within bracket.
My lord, WPC number
Indian Oil Corporation
122.
1279.
My lord.
Indian Oil Corporation Limited within bracket marketing division versus the state of Assam and others. Had observed that there was nil demand for the assessment year 1994-1995
As per the demand notice.
as per the demand notice after as per the de novo assessment.
Well, after the, as per the is medicine demand notice. Well, after the de novo assessment, the demand notice after the de novo assessment.
There was nil demand.
Nil demand.
After the for the assessment year 1994-1995 after de novo assessment, and as such, there was no question of payment of interest against nil demand. Full stop. The Appeal or SLP?
SLP.
SLP. The specially petition will make a civil diary number 16907/2017. Prepared by the state against the order dated 11/3/2015 came to be dismissed by an order dated 10/11/2022. Full stop. In its order, in the order dated 10/11/2022, Common Honorable Supreme Court had observed that the Honorable Supreme Court had declined to interfere with the order dated 11/3/2015. So it was, however, verified that case 52, that's the in terms of the judgment dated 27/11/2006, passed by the Honorable Supreme Court in Civil Appeal number 6619 of 2001, titled, quote, Indian Oil Corporation Limited versus State of Assam and others, 2007-11 SCC 693. The Indian Oil Corporation Limited would be liable to pay sales tax on the differential amount along with interest as per statement. It has been contended that since the demand was nil, since it was observed by the Honorable Supreme Court of India, by the division bench, that since there was nil demand for the assessment year 1994-1995, there could not be a question of payment of interest for such nil demand.
And this was done after examining the province of the appeal.
Full stop. It has been contended that the order dated 11/3/2015 was passed after considering the provisions of the relevant provisions of the AGST Act 2003, more particularly section 22. 22?
Between 1993, my lord, Act 1993.
1993.
Instead of 2003, my lord, 1993.
Oh, 1993. And as the SLP preferred against the state order has been dismissed with no interference to the order dated 11/3/2015 passed by the division bench of this court, the respondent number 3 could not derive any jurisdiction to consider to reach a finding that interest is leviable. Issue notice returnable forwards.
The next case, the assessment year 1996-97.
Extra copies has appeared and accepted notice on behalf of all the respondents. No formal notice. Extra copies within 3 working days. Yes.
Next is the assessment year 96-97.
1 minute.
At page 54.
Okay. 1 minute. Okay, 94-96 য'ত আছে 96-97 দিব আগতে এটা ফিগাৰ দিছিলো 26 লাখ এটা কিবা কৈছিলো ন তাৰ ঠাইত 32 lakh
32 crores 37 lakh
32 crores 37 lakh 77 1,568. Okay,
And the WPC number will be, my lord,
WPC number
1282,
1282 of
2008.
বুঝছে change করিব এটা। Any other changes?
No, rest are the same, my lord. I am obliged. my lord. Number 13.
Lordship, regarding non-payment of arrear compassionate family pension for a period of 2 years, my lord.
Service matter,
My lord,
High Court.
I got that. Then I'm
Read.
of season, my lord.
Okay. What is this pension?
But compassionate family pension.
Huh?
Compassionate family pension, my lord.
Compassionate family pension.
My lord, this is the new scheme which was notified 14 September 2017, my lord. In this case, in case of compassionate appointment, my lord, this compassionate family pension is to grant to the
Compassionate,
page 14, my lord, is the notification. One.
scheme for compassionate. Okay. Scheme for compassionate family pension
My lord,
in lieu of compassionate appointment.
appointment, my lord.
Okay.
My lord, till age of superannuation, deemed superannuation, the my lord family is entitled to get 100% of the salary, my lord.
What is the provision? Which,
My lord,
which
page-
is the relevant?
Page 14, my lord. 1/4.
Page 14, which is guidelines.
My lord, guideline.
1 minute.
My lord, page 15 will be relevant. 5.5.
Since a long time, I have not been dealing with compassionate appointment, so I am not aware.
Now, my lord,
Yes,
from 6, 9.
I am not.
Lordship.
So it appears that this compassionate appointment
No more
thing is
exists,
Lord.
not in existence now.
Lordship.
And if the employee dies during his service period, then his family will get
100%
the same pay
salary.
till the date of
Is
the
retirement.
superannuation, that
Lordship.
employee's superannuation.
Lordship.
Okay. Okay.
Now, my lord, she is entitled to go from.
Now, who is she?
She's the wife of the
Wife of whom?
wife of my lord, late
Ratnodip
Ratnodip
Nath,
Nath, my lord.
copyist,
Copyist, my,
died on 5/9/2017.
my lord. He's entitled to get from, she's in 17 to 31st, 10/2019, my lord.
This scheme has come from which date?
So, my lord, from lordship, it starts from my lord.
Giving effect?
The effect 1/4/17, my lord.
Huh?
In the notification itself, my lord, clause
Where,
5.
which page? Which page?
Page 15.
Page
lord,
15. Let
my
us
lord.
see.
5.11.
5.11.
The scheme is applicable to
Okay.
those employees who died on or after 1/4/17. However,
So it is applicable to him.
Lord,
Then what is your given?
now, my lord, for 22 months, my area family compassion, 22 months, my lord, from 6/9/17 to 31/10/2019. This period has not been paid to me, man.
Where have you stated?
In my paragraph, in my
You are receiving this compassionate family pension
My
from
lord,
when,
and-
which date?
my lord,
From which month?
from my lord, 1/11/2019, my lord,
1/11/2019.
19, my lord. And
So meaning thereby September 2017
my lord,
to October 2019.
19, my lord, only this period, my
This
lord.
is hard. Mr. J. Losco, Learned Counsel for the petitioner. Mr. Sharma, you are for one.
I am for one, lordship.
Mr. J. H. Sharma, Learned Additional Senior Government Advocate Assam for the respondent number 1. MS S. Sharma, Learned Training Council.
2, 3.
ZHC for the respondent number 2 and 4. Finance. RM Borua, Learned Council, representing Mr. B. Gugoi, Learned Training Council. Finance Department for the respondent number 3. And Mr. R.K. Talukdar, Learned Training Council. Accountant General within bracket A&E, Assam for the respondent of 5. The petitioner's husband, late Ratnodip Nath, who was a copyist in the establishment of the respondent number 4. Full stop. The petitioner's husband died in harness on 5/9/2017, leaving behind the petitioner, within bracket wife, and his mother.
I think lordship, a short notice will go, lord. A short notice will go at this time.
The notice is full stop. The state government has notified a scheme, is 49 quote, scheme for compassionate family pension in lieu of compassionate appointment, unquote. In short, quote, compassionate family pension within a CFP scheme, unquote. As per the compassionate family CFP scheme, when an employee when a government servant, when an employee, when a government servant dies before annuition, the family pension equal to clause 5.3, the family pension equal to 100% of the last pay drawn by the deceased employee is to be paid, is payable for a period up to the date of deemed superannuation of the deceased employee, i.e. the date on which the employee would have superannuated had he been alive. Full stop. The grievance of the petitioner is that The petitioner has been paid family pension under the CFP scheme only from November 2019 onwards. Full stop. The petitioner has claimed that the petitioner is entitled to receive family pension from the period uh, during the period, for the period from September 2017 to October 2019, as the scheme has been given effect to, as the CFP scheme has been given effect to on or after 1/4/2017. Full stop. Issue notice returnable. I think this is a short issue.
Lordship, the date may be fixed, Lordship,
Ah.
that will be.
This issue notice returnable on February 16 to 2024. The respondent shall make as so and so appeared and accepted if it is no formal notice. Extra copies within 2 working days. The respondents shall make endeavor to file their respective counter affidavits on or before the returnable date, so that the petition can be considered so that an endeavor can be made for final consideration of the petition on the returnable date.
Apply.
Number 14.
My pleasure, Lordship. My lord, in this case, my lord, the present petitioners, my lord, they filed a title suit in the year of 2007, my lord, and 2011, learned trial court, my lord, a preliminary decree was in their favor, my lord. Then, my lord, only the share, not partitioned, we filed a partition suit. Where the judgment, my lord, only share is reflected, but not partition. Then we, my lord, inadvertently we filed an execution case before the same court, my lord, and this executing court said, until and unless partition, my lord, the executing case is not maintainable. Then we challenging this case before this honorable court, and this honorable court on 29/10/21, my lord, there's
By writ petition.
no, CRP we have filed earlier, my lord. And that case, my lord, this honorable court under section 20, there is a provision under section 54 of CPC, order 20 rule 18. So you may file in this application for partition before the district collector. Accordingly, we have filed a demarcation case before district collector, my lord. And 2020-22, our case is registered in 2023, my lord. Thereafter, more than, my lord, 4 notices, circle officer issued 4 notices for a demarcation of the our land, my lord. So what happened, my lord? And all these occasions, my lord, they are not finalizing our matter, and we therefore even 4 times we have made a representation, my lord. There's no progress in our case. So we are.
So why writ petition?
So we are before this court since our mate is before the district collector is the state authority, my lord. So our case is pending there. No access, no progressing our matter, my lord.
Why writ petition?
Lordship,
Why we will meddle into this demarcation affairs?
Lordship may kindly come to page 54, Lordship. That is the order passed by this honorable court.
That was passed in CRP.
Yes. Whereby they have been directed to approach the appropriate authority, that is the district collector.
All these are out of civil
Yes.
suit,
Yes.
title suit, partition, execution
No,
case, CRP.
Madam, we are not here before this court to get the demarcation order, my lord.
Now,
we are before this court, my lord.
Why this Board of Revenue is sitting?
My lord, Board of Revenue, we have check it, my lord, one order of judgment we have filed, my lord. If any impugned order passed by the district collector, then we can challenge before the revenue. But at this stage, our no progress of our matter, my lord. So we are before this court, the direction to
We
district.
can only issue notice, we will examine it, but
Yes.
we are not.
Yes, my lord.
Yes,
Lord.
or Mr. P.K. Planning Council for the petition. One authority is executing or proceeding with the matter, another parallel proceeding.
Lord.
To supervise that proceeding. Petition, please. State of Assam cannot be represented by deputy commission, district commission. Wrong. We don't think.
No, Lordship. It is to be by the chief secretary.
Correct it. Cannot be.
Then my lord,
There is a decision also,
Lordship.
the division means.
then
It
my
should
lord,
be by the chief secretary.
And now we cannot correct by hand.
absolutely, my lord, we have to file II, my lord.
It is up to you. On the prayer of Mr. P.K. Dekas and counsel for the applications, raise the case up to you in a motion.
Yep, yep, yes.
You take
Yes, yes.
immediate measures.
Yes,
We are not here for advising you,
my lord,
right?
yes, absolutely.
May I please?
Hmm.
My lord, the petitioners are, my lord, landless people, my lord, who have been, my lord, possessing a particular plot of land since 1963 from the days of their, my lord, grandparents. Now, they have been, my lord, threatened to vacate the, my lord, said land by impound notice, my lord, dated, my lord, 23/3/23, issued to one some Mojit Ali, not to the petitioners. My lord. Now, the notice lordship will find at page 54, impound notice. And page 54 is the my lord, vernacular that was issued to on Mojit Ali, but not to the petitioners.
Yes.
Now, my lord, as per the my lord, policy, my lord, 2019, they are entitled to my lord, get some portion of
2019.
19. my lord.
Which clause?
Land policy, my lord, page 24, lordship will find.
Twenty-four, yes. Which clause?
Rose, my lord, page 25, my lord, close on, my lord. Page 25, close on, my lord.
This is allotment and settlement.
Yes, my lord.
There is no allotment.
Yes, since my lord, we are seeking my lord, allotment, settlement before the my lord, competent authority. Now, my lord, lordship will find the,
Where is your application for settlement?
yes, my lord, the representation pending before the my lord, district commissioner, lordship will find
Representation will not do.
page 41 and 47 also.
Public prayer. Public prayer. Individual application, that is Kabula.
My lord.
Kabula has to file, has to be filed. Not public prayer. There is a proper procedure.
Yes.
Individual application has to be filed for a settlement or allotment. Public prayer will not do.
Lord, page 48, lordship will find the petition number 1
Same
and the others.
public prayer.
Yes.
Same public prayer.
Page 48, then 59.
There has
lord,
to be individual application.
Yes.
Kabula.
Well.
Seeking allotment of land. There, this much land, I 1 katha or 1 bigha, I am in possession of government land.
Well.
So please allot me in my name. Individual name. This public prayer is not in accordance with the prescribed procedure.
But we will file my lord, petition before the competent authority. My lord.
Here is that threatened eviction
My lord.
by serving a copy only to one person.
My lord. Page 50.
Yes. Your application regarding allotment, you, it is up to
Yes,
you. to
Yes,
prefer.
individually we will
It
file.
is up to you prefer as per the prescribed procedure.
Mal-
My begging public prayer that please give 17 bighas of land, that cannot be. That is not as per the policy.
Yes.
If we let us read the policy.
Yes, policy is not, one individual has to
Uh,
in a prescribed form.
yes, so far as threatened eviction is concerned,
Well, this is.
their
to-
allegation is that they have not been served individual notice.
They are.
Without-
on- Yes, Malad, that's not necessary even. in
We
my
can say
opinion.
that there shall not be any coercive action like eviction without following the due procedure of law. That is, the petitioner should not be evicted without preceded by any individual notice. You have served, you have taken the botheration to serve a notice on Mojid Ali, saying that he is encroaching 17 bighas, 3 kathas of land. If that is correct, okay. Page 55, Mojid Ali, under 18(2), জমি 17 বিঘা 3 কথা 12 লেচা।
আপোনালোকে বেদখল কৰি আছে।
Here, before the court, there are about how many? 15.
15.
Heard Mr. M.U. Mondal, Learned Counsel for the petitioners. M.S. S. Sharma, Learned Junior Advocate of some for the response number 1, 3, 4, 5. M.S.G. Hazarika, Learned Standing Counsel, Revenue and Disaster Management Department for the response number 2. Full stop. The petitions, comma, 15 in number, comma, have claimed that the families of the petitioners, since their predecessors, comma, are in occupation of an area of land any details?
Say 17 bighas, 3 kathas, 12 lectures, covered by DAG number 179.
Measuring about 17 bighas, 3 kathas and 12 plazas situate at
Well, not on the
covered by-
body, not on the body of the petition, my lord, only on the in the synopsis.
covered by
No, my lord, they are not clear.
huh?
They are not clear where they are situated. Not on the body of the petition, my lord. They speak of the eviction notice on DAG number 1, in respect of DAG number 179,
Para 4,
para 5, my lord,
para 4.
praying for allotment of government.
On the ground of continuous possession.
My lord.
Covered by DAG number 179, comma, situate at village Kaslar Tari, Part 1. Bilasipara Revenue Circle, District, Hubri, within bracket, the subject line. Since 1963 onwards. If you had landed properties earlier, why you are not submitting landed proper documents? Land documents? You have mentioned due to erosion of their landed properties.
Yes. Right.
By the mighty Tipkai River. But there is no semblance of any
Right.
document. But we'll furnish on additional evidence in due course. I have been instructed, my lord, they had land.
Stop. The petitioners have approached this court by the writ petition stating that an apprehension there is an apprehension that they would be evicted from the subject land as one Mojid Ali has been served with a notice under Rule 18 within bracket 2 of the Assam Land and Revenue Regulation 1886 on 23/3/2023 by the respondent number 5, stating that he, within bracket Mojid Ali, is in occupation of the entire subject land. Full stop. As the petitioners have claimed that as the petitioners are also in occupation of plots of land within the subject land, they are also sought to be brought within the purview of the said notice dated 23/3/2023, without serving any individual notices upon them. Hence the writ petition. Full stop. Issue notice returnable on last part 19/2/2023. As MS Sharma, current junior government advocate, has appeared and accepted notice on behalf of the respondent number 1,
1, 3, 4, and
3,
5.
4, and 5, and MS Hajurika, Standing Council Revenue Department has appeared and accepted on notice on behalf of the respondent number 2. No formal notices need to be issued to the same respondents. However, the learned counsel for the petitioners shall serve requisite number of extra copies of the writ petition along with annexes to MS so and so within 2 working days. Full stop. Having regard to the assertion made that 7 accept Mojid Ali seven accept serving a notice under Rule 18(2) of the Assam Land and Revenue Regulation 1886 upon Mojid Ali, one Mojid Ali on 23/3/2023. Annexure 6. No notices, no individual notices have been served upon the petitioners. Till date, though the petitioners are also in occupation of the same seat subject of Kama. It is observed that there shall not be any eviction process. Without, in respect of the petitioners, without preceded by any individual notice under rule under the settlement rules framed under the Assam Land and Revenue Regulation 1886 till the returnable date. Developers.
16.
My lord, the petitioners are praying for release of the family pension due to their mother, my lord,
who was receiving family pension under the Swatantrata Sainik Samman scheme, my lord. Originally their father was a freedom fighter, and he started receiving Swatantrata Sainik Samman pension from 1972, and he died in the year 2000. And thereafter, her mother started receiving the family pension. And
What is the name of the scheme?
Swatantrata Sainik Samman pension scheme, my lord.
By central government or state government?
Central government, my lord.
By the central government.
Yes, my lord. And what has happened, from March 2016, the family pension due to the mother of the petitioners was stopped. And thereafter, she approached before this honorable court because
The petitioner's mother, comma, late, okay, Khameswari Hoikia. Khameswari Hoikia was a recipient of
page 39.
where have we mentioned about the scheme?
My lord,
Which paragraph? The name of the scheme?
my lord, paragraph 2.
2.
That their late father Torun Soikia received central freedom pension with effect from 15/8/1972 by P.
Okay, then mother okay, was a recipient of Central Freedom Fighters Pension. After demise of her husband, late Torun Chandra Hoikia, who was a freedom fighter. Full stop. The petitioner's mother, Khameswari Hoikia, who expired on
19/2/2020,
received the pension
till March.
amounts till March 2016. Full stop. Though pension was payable to late Khameswari Hoikia for the period from 1/4/2016 to 19/2/2020, that is till her date, the respondent authorities have not paid the said amount till date. Hence the repetition. So I would leave out Mr. M. Khatonia for the petitioners.
I appear for respondent number 1, 3, and 4.
Mr. Pegu,
My lord.
G. Pegu, Central Government Council for respondent number 1,
3 and 4.
3, 4. Accountant General
R.K. Talukdar will appear, my lord.
R.K. Talukdar and
For him.
Standing Council Accountant General A.E. Assam for the respondent number 2. Issue notice, returnable on as so and so appeared and has appeared and accepted notice, no formal notice, extra copies. Within 2 working days, the petitioner shall take place for service of notice of the respondent number 5, 6, and 7 by registered post with AD within 3 working days.
23 Item number 17.
My lord, if I may interfere, in last order, the name of the scheme was Swatantrata Sainik Samman Pension.
Family pension.
Family pension.
Swatantrata, where it is mentioned?
My lord, in annexure, last annexure, that is annexure N.
Because you were
Page 30.
conspicuously silent about the scheme.
Yes, my lord, page
In
39.
the entire petition. Page
39, my lord.
39.
Swatantrata Sainik Samman Family Pension.
In the subject, it's written, Swatantrata Sainik Samman.
স্বতন্ত্ৰ সৈনিক সন্মান যোজনা
Case 39 চাই যাব স্বতন্ত্ৰতা সৈনিক সন্মান
যোজনা
ফেমিলি
পেঞ্চন
যোজনা যোজনা Case 39 বটে
May it please your lordship. Under the Assam Mala project, my land was acquired by the government, Malad. I made a representation. There is a title suit pending along with, against the respondent number 6. I have submitted my Jamabandi copy and representation to the deputy commissioner. But the respondent number 6 is becoming the beneficiary of the amount. So Malad, that is why I am before your lordship.
What acquisition process?
Assam Mala project.
Assam Mala project. What is the land details?
Mala land details is 1 bigha, 1 cut 13 lesser, covered by Dag number 76, periodic patta 158. Jaintia Basti under Hojai Moja in the district of Hojai.
1 bigha, 1 katra, 13 lakhs, covered by 20.
My representations I have before the deputy commissioner, but at page 20, your lordship will find both of us, both the parties were called for hearing.
No, you have mentioned two lands. One in paragraph 3, one in paragraph 4. Which one is under acquisition?
My lord, that acquisition is your lordship may turn to page 20.
No, which paragraph? 3 or 4?
My lord, it is paragraph number 3, my lord. Other is the.
You have said about 1 bigha, 1 kata,
My
13 lassa
My
in
lord,
paragraph 3.
my lord.
Then you have said about some other Dag numbers in
But
paragraph
Dag number
4.
was 76 and periodic patta is
Huh?
158.
Let us see now your Jamabandi.
Jamabandi annexure 1, page 12 onward.
Which part?
My lord,
Name
serial
of
number
Nehar
49.
and so is meted in so and so. Dag number 76.
My lord, page 16, serial number 49 and 50.
Page 16.
In the vernacular, page 49, serial number 49 and 50.
49, 50. Where is that entry?
My lord,
On the right side?
left hand side,
No,
49.
no, that I have seen.
My lord, and the
49, 50 I have seen. Where is the remark?
remark, my lord, your lordship will find this Dr. Visha, it is at my lord serial number for right hand side 1.
Right hand side. Which
1,
page?
2, 3, page 16.
Page 16 itself.
My lord.
Let us see.
My lord, your lordship will find 158 number Patta, 76 number Dagor.
No, page 16. Which one?
My lord, right hand column, right hand side
Right
column.
hand. I am looking at right hand.
1, 2, 3, 4, 5, 6, 7, 8. Serial number 8.
There is no serial number 8.
But
It
from
is
bottom, if I
jaw like this.
it's jaw, it should be jaw.
Jaw. That is Abdul Latif Kiramat Ali, jaw.
I have given that my lord here in my representation at page 21, my lord. And my lord, at page 20, your lordship will find both the party was called for the hearing, man.
I want to see it in the Jamabandi remarks column. You have not been able to indicate.
Page 17. মোক নম্বৰ পট্টদাৰৰ লগত 4 বিঘা জমিত মোহাম্মদ Moinuddin Jalaluddin Fakhruddin নামে নামজারি করা হয় my lord. Page 17. Act
They are not Moinuddin, they are Amina Anjuma.
Moinuddin was the father's name.
Father's name, my lord.
Father's name, and they.
Which one? Say page 17?
Page 17, Act 2, Tinisari pass.
You don't know do, tho, do, no, do.
Eight from top.
Moinuddin.
God, dha.
Moinuddin.
The 8th paragraph from top.
Moinuddin, Jalaluddin, Fakhruddin.
Yes, my lord. She is Mito Moinuddin. Amina Anjuman.
The
Mito
daughter of
Moinuddin. Unknown.
Haji Moinuddin.
Haju.
That is 4 bigha, but their names are reflected in the Jamabandi, so their names are also mutated. Mr. Roy Chaudhary.
Mito, it was the father's
Ah.
property inherited by the
No,
daughter.
you have stated how their names can be reflected in the Jamabandi without any mutation order.
Through mutation.
You are not able to show me. And you have wasted more than 5 minutes time.
My lord, your lordship will find.
Tho, tho, jo, jo.
Jho, my lord, jho. At
Oh.
7.
I have not been able to show. Why should I go on reading?
My lord, at
Yes, madam. Why you have not?
jho, my
What
lord.
is your job?
Moinuddin jho, my lord.
Moinuddin, I have seen Mr. Roy Chaudhary. Now you are indicating 49 and 50.
49 and 50, my lord.
Oh, page 16.
Their names are there through mutation.
Their names are there. Is to be reflected in the right hand column.
Yes.
That is what I am asking for.
Because it was written Mito Moinuddin.
Oh,
Thereafter.
come
it
back
was-
after looking at the records. We'll take up after some time.
No.
This will not go to further your case.
My lord, I will
If
look
I
into it.
indicate in the order only, then only you can.
My lord, I will look into it.
Item number 18.
Forest will be covered, yes, sir.
Forest will be covered. Yes, where is the order? Yes, Mr. Botakur and Mr. Bora.
You like it? Yes, it is
Individuals.
covered.
Itu no, itu no. Individual.
Individual.
And my order pass করা আছে এই ফরেস্ট রেঞ্জ D. Burua, petitioner. I, Botakur, Council representing Mr.
PN Goswami for
P. N.
forest.
Goswami. Standing Council, Environment and Forest Department for us. Point number 1, 2. 1 and 2. Mr. S. Bora, Standing Council, Urban Affairs
PNC.
Department and ZMC for the respondent number 3 and 6. And MS S. Sharma, Junior Government Advocate Assam for the respondent number 4 and 5. Where is that annexer?
Page 40, annexure 4.
41. Annexer 4.
40 is the type copy.
P. Okay. Paragraph 2. ইয়াতে paragraph 2 annexer 6 বুলি আছে পেকেটত হা annexer 4 কৰি দিব The petition has averred that he is the absolute owner he owns and is in possession of a plot of land measuring paragraph 3 আছে। Paragraph 3 to কোনটা? Paragraph 3 sorry, paragraph 3 details তো আছে, চেঞ্জ করে দিব, ভাগ নাম্বার পট্টা নাম্বার চেঞ্জ করে দিব। সিটাকে এই করে দিব। Two point, sign my use, no? Issue notice to কৰিব। এইবোৰৰ ঠাইত চি কৰি দিব দেই, চি ঠাইত এই কৰি দিব। Issue notice returnable in Puritha.
Number 19.
May I please, Your Lordship? Lordship, impunity notice issued by the Excise Department levying certain establishment cost. Our contention is that we have paid the amount which was supposed to be paid on as on 1st September 2016 after the new excise amendments came into effect. In spite of that, they have issued the notice to us.
Which one?
Notice is at page 18, Lordship, which starts.
18.
18. They've given the salary statement subsequent to the annexure 2, Lordship.
Basic pay they are demanding.
Basic pay for the establishment charges, Lord. For the and Lordship, the matter has
Period is about April 2022.
Yes, Lord, up to October 2020.
Since when?
Since January 2018. Lordship, similar issues has been decided in a different writ petition. Exactly similar, Lordship. If I may place the order, if Lordship wants to go. Right.
Mr. Yes, Mr. Botagu.
Lordship, the issue here is that their dues are not clear because establishment charge is tied with VAT and levy. And because their VAT and levy is not clear, in fact, VAT, value added, yes, and levy. And in fact, Lordship, there is another writ petition filed by them where they're disputing the tax, the levy and the VAT. And because of that, the establishment charges will have to be borne by them because the establishment officers cannot be withdrawn until all their dues are clear. So as such, their dues are not clear.
Lordship, that if Lordship takes up page number 4 of the order passed by this honorable court in another writ petition, Lordship. That must
Lordship, that order makes a similar observation saying that if no dues certificate is produced, then there might be
only thing is
a waiver, but
the
their
order,
dues are there.
Order gives a chance to the petitioner to establish their demand that they have made the payment before the excise officers, which is otherwise not available.
You submit your response. In the meantime, don't proceed with this notice. Make your stand clear.
We'll file an appeal.
Heard Mr. D. Decker. Learned counsel for the petitioner. And Mr. I. Botagu. Learned counsel. Appearing on behalf of Mr. P. N. Luthra. Learned standing counsel exercise for all the respondents. Good stuff. It is the case of the petitioner that they earlier operated a bonded warehouse of liquor under the respondent excise department authorities. Full stop, on and from 30/8/2016, comma, the new Assam Excise Rules 2016 came into effect, and under the new regime, comma, excise regime, comma, the maintenance of bonded warehouse for stocking liquor was done away with. Full stop. As per the Assam Excise Rules 2016, comma, entire stocks of liquor are to be prepaid in terms of ad valorem levy and PAT on such stocks. Full stop. As per the earlier regime of bonded warehouse, comma, officials of the respondent excise department authorities were used to be posted in a bonded warehouse for keeping track of stocks of liquor in the state in the bonded warehouse and to maintain the details of the tax to be paid by such bonded warehouse. Full stop. With a new regime given effect to on and from 2016, comma, the such arrangement. No, so as per the earlier said arrangement, comma, it was the bonded warehouse who was concerned bonded warehouse who was responsible to reimburse the cost incurred by the respondent excise department in terms of the salary, comma, allowances, etc. of such officials who were posted in the concerned bonded warehouse. Though under the Assam Excise Rules 2016, the posting of the bonded warehouse has been done away with, and consequently, comma, the posting of officials also. Yet the petition has been served with a notice dated 20/12/2022 within bracket annex R2, whereby the petition has been asked to deposit the area establishment charges amounting to rupees 41,06,280, paragraph page 18, WEF January 2018 to October 2022. Aggrieved thereby, the petitioner has preferred the instant petition challenging the said notice dated challenging inter alia the said notice dated 20/12/2022. The petition, according to the petitioners, that they have been paying ad valorem levy and PAT since 2016. And as such, comma, the demand notice dated 20/12/2022 asking for area establishment charges is illegal and arbitrary. First, Mr. Bottabul and council, attending council, planning council appearing for the respondent excise department authorities has submitted that the petitioner has not yet cleared the entire outstanding dues as per the earlier regime, which was in place prior to the Assam Excise Rules 2016. And as such, the respondent excise department has to maintain the officials for the said purpose. Full stop. Mr. The counsel for the petition has submitted that the issue raised in this writ petition has been settled by a number of orders passed by this court, including WBC number 6479/2022. Issue notice returnable in 4 weeks. As Mr. Bothago appeared accepted for all the respondents, no formal notice, extra copies we can access within 2 working days, having regard to the projections made. And the observations made in the order dated 22/12/2023, whereby WBC number 6479/2023 has been disposed of, it is observed that there shall not be any coercive action against the petitioner in terms of the notice dated so and so till the return of it. Any of that.
Number 20.
May I please, your lordship? Lordship, in this case, your lordship, petitioner is the wife of the deceased, your lordship, who had expired on 10/5/2000.
SI account petitioner G. Hazarika, Revenue Register 1, S. Sharma, Junior Government Advocate, Assam 3, 4, and 5, R.M. Borua, Attorney Counsel representing Mr. B. Gugul and Standing Counsel Finance Department for Respond number 2. Liquidivo ex gratia in terms of the notification dated so and so. The petitioner is the wife of one late Azmat Ali. First of the petitioners claimed that Azmat Ali had succumbed to death in a road traffic accident occurred at a public place on 10/5/2020. Perhaps notification returnable in 4 weeks.
21. Item 21.
May it please your lordship. And before your lordship, again preventive detention, your lordship. Is at page 29 to 40, your lordship, along with the grounds of arrest.
At this stage, you can issue notice expecting immediate reply from the state.
Yes, my lord.
Which one is the order?
Order is at page 29, your lordship.
No, that has been confirmed.
Lordship.
Basically, 29.
29, it's a type copy, your lordship.
Type copy.
Here, 29 is the type copy, 33 is the lordship, the copy.
13 July.
33 page number. Copy.
Zubaid Ahmed Khan.
Zubaid Ahmed Khan, your lordship.
NDPS case.
NDPS case.
Commercial quantity.
It's not commercial, as many as three cases being registered, 2 cases already been, your lordship, on plea of guilty, acquitted, your lordship, and against one cases, there is prosecution witness is in
Or
progress. your lordship.
Mr. A. Diwan. Learned counsel for the petitioner. MS S. Sharma, learned Senior Government Advocate Assam for
All the
all the response. The petitioner has preferred the instant repetition against his detention.
Lordship.
under the provisions of
Provisions of your Lordship.
the
3-1.
Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act 1988. Full stop. The petitioner has alleged that such preventive detention is illegal and arbitrary and without following the provisions of law. Full stop. Issue notice returnable on
23 to.
Lordship, I may be fixed along with you, Lord, WBC number.
when that was fixed.
Next date is not notified, your Lordship. The last date was 9/1/2024, your Lordship. Case number WBC number 666-1/23, your Lordship.
Same or different or the accused are
Accused are different, your Lordship.
different, but police cases are
Police
same.
case number not same. Police
Not
case number
same.
not same, your Lordship.
We'll fix a date on this case. We'll fix a date.
23 to.
23. As so and so appeared, accepted. It is expected that the state respondents shall file their counter affidavit on or before. Considering the fact that it is a case regarding preventive detention, it is expected that the state respondents will file their counter affidavit on or before the returnable. Don't delay.
22.
Please, Your Lordship, I appear for the petition. Lordship, this is a GST matter. I was audited under section 65 of the law, Lordships,
GST.
wherein department has the powers to conduct audit for a particular financial year. That audit started on 1st of July 2023, Lordships. That is at page number 28.
20.
I received this notice for conducting audit, Lordships.
Hmm.
Then during the course of audit, documents were submitted. We appeared before the authorities, and after verification of the books of accounts, an audit discrepancy note was issued on 13th of December, Lordship, which is at page 31. This audit discrepancy memo, Lordships, was replied to us duly on 17th of December, which is at page 33. Post this, Lordships, the final audit report had to be issued. They issued the final audit report on 8th of January, but prior to this, the Jorhat division of the state GST issued me another show cause notice for the same period. When the audit is already pending before the audit sale for the entire financial year, the Jorhat state GST division issues me a show cause notice for the same financial year, which is the impugned show cause notice at page 37.
1 minute. The first notice, that is page 28. Who has issued it?
This has been issued by respondent number 4, the audit wing, who is authorized under the provisions of the law to conduct audit of my books of accounts. GST audit. Respondent number 4, Lordships. Then, Lordships, after the audit, they issued a discrepancy memo, which is at page 31. The observations of the audit. There were various points, Lordship, during the course of audit. Finally, they came out with this observation, which we couldn't satisfy. This we replied, Lordship, at page 33. This is all being conducted by respondent number 4, Lordships. Now, Lordships, after our reply dated 17th of December 23, they issued us a final audit report at page 50, which is dated 8th of January. Page 50, Lordships.
What is this page 37?
37, Lordship. So, Lordship, the audit was pending.
37.
Page 37 is the impugned show cause notice in this proceedings, before your Lordship in this writ petition. This, Lordship, this has been issued by respondent number 2.
No, this is page 37.
Lordships. The detailed show cause notice.
pursuant to page 28.
No, Lordship, that is what. Pursuant to page 28, the show cause is at page 51. Kindly takes up page 51. Pursuant to page 28, Lordship, the audit proceedings, the show cause is at page 51 dated 11th of January. I am not challenging this show cause before your Lordships.
No, go one by your document. Don't take here to annexer 1, then annexer 5. Go slowly.
Lordship, page
Come to
28.
page 28.
28, this is the first notice when my GST audit started. Department intimated that you will be audited by the department.
Right.
Then after the audit, they issued me a discrepancy note at page 31 after they conducted the audit for 6 months. These were their
Right.
observations. I
Then
replied
You replied.
at page 33.
Okay.
Then Lordship, they issued me a final audit report at page 50.
What is this page 37?
Lordship, this page 37, because of the sequence of the dates, before issuance of final audit report, another wing of the state GST department for the same financial year has issued me a show cause notice. First, Lordship, I am taking you to the respondent number 4 proceedings. At page 50, Lordship, they issues me the audit report. Dated 8th of January, Lordships. After that, Lordship, on 11th of January, page 51, the same audit report is issued in form of show cause notice, which I have to reply. The detailed notice starts at page 54. 51 is the form, 54 is the detailed notice. It is culminating out of the proceedings of audit, Lordship. Now, Lordships, when this proceeding was pending before the state GST department, suddenly on 21st of December, on 11th of December, on 21st of December 2023, the Jorat wing of the state GST office issues me a show cause notice for the same period when the audit is already pending. That show cause notice is at page 37, Lordships. And now, Lordships, to address this issue, the state of Assam has come up with an instructions on 26th of December. Lordships, their instruction.
As per the notice, what is the audit period?
18-19, financial year 18-19, both the periods, both the matters. Lordship. The same financial year which was under audit, Lordship. Kindly takes up page 28, financial year 2018-19. Period, Lordship, in the top, after my address, period 18-19. Page 28. And Lordships, the show cause notice at page 37 also, financial year 18-19. And the show cause at page 51 also, financial year 18-19. Because how did that show cause at page 37, which is the impugned show cause before your Lordships came? That was because state of Assam came up with a circular on 26th of December stating that they had hired some IIT software which would pre-fill a show cause notice and send it on automatic basis to the SSCs, basis the return filed. And the department has categorically stated in the instructions, if the audit is already pending or audit has happened, then that show cause has to be withdrawn, which has been sent by at page 37. That instructions, Lordship, kindly comes to that instruction at page 64, Lordship. Page 64, Lordship, this is the instruction 13/23 dated 26 December, issued by the Commissioner State GST. Lordship, attention is invited to IIT Big Data Software, which has been procured by the Commissioner of Taxes, Assam, for ease of preparation for the judicial offices. With the help of this software, automated notices in DRC 01 can be generated based on different parameters. Representations have been received that even though taxpayers have been assessed for cases like scrutiny, audit, and advisory summons, but the notices have been issued again for the cases for financial year 17-18 and 18-19. Considering that in the initial years of GST implementation, a lot of practical difficulties were encountered, it is hereby advised to drop the proceedings, keeping in mind the following instructions. Number 1, In those cases where audit proceedings have been completed, the notices again using IIT Big Data software needs to be dropped. Exactly my point, Lordships. My already audit was pending, now it is completed. In meantime, suddenly they issue me a notice. Lordship, then they have given separate in para number 2, the cases where return scrutinies have been completed and notices again issued using IIT Big Data software needs to be dropped to the extent the para which were already covered in the previous notice. Now, Lordships, the serial number 9 of that instruction, Lordship, page 65. Serial number 9, Lordship. With respect to the above mentioned criteria where notices are not required to be dropped, then in those cases, notices shall be served in appropriate manner. An opportunity of being heard is to be given to the taxpayer and proceeding to be concluded in time-bound manner. So, Lordships, audit already completed. When audit is already completed, the notices issued basis this IIT Big Data software has to be done away with. The notice which is impugned at page 37, Lordship. Page 51 notice, I am replying. I am under adjudication. Should I read last para of page 65? Page 65, Lordship, after serial number 9. The above instructions shall be followed strictly. The cases where notices are required to be dropped, then neither any written submission is to be called for, nor a taxpayer is required to be called for a hearing. In such cases, the proper officer, after recording reasons, shall drop the proceedings on the basis of facts and contents of each cases.
Yes, Mr. Surri.
Lordship, why the show cause notice at page 37 was issued? Lordship, when there is audit proceeding is pending, Lordship, that I have to take instruction.
Take
Because,
your instruction, if this is to be dropped, this is to be dropped. Why
Yes,
prolong the
yes.
proceeding?
Because, but
Why unnecessary prolong a proceeding and also a writ petition? It appears prima facie that for the same period, for the same establishment, two notices.
But Lordship, that's an audit,
Same
assessment,
Same
but
period,
this is
Gaur Ali-
about the
Gaur Ali
discrimination.
Julhad. I
But-
examine whether
Lordship,
these
the
are
sections are different. That is under section 65 and this show cause notice at page 37 is under section 73. Lordship.
both are 73.
No,
Come to Mr. Come to page 54. Did not.
Lordship, it is, Lordship. Parallel proceedings.
Both 73.
That is-
Lordship, but the
For the same period.
but in notice for conducting audit, it's clearly stated that section 65. Lordship, this may be culmination of this page 37, Lordship. Lordship, I'll take the instruction, Lordship.
See, 65 under 65.
Page
It was
28.
undertaken,
Yes, Lordship.
right?
Lordship,
Noted observation was made.
Lordship.
Then they have replied. Then it should be culminated into a order under
Audit
Yes.
report at
Audit
page
note.
page 50, Lordship.
65-6.
Lordship, 65-6.
So it had resulted.
It has resulted, Lordship.
Page 50,
Page 50.
right?
And then the show cause.
Next step is show cause
Lordships.
under section 73,
Yes.
right? Now, from where this has emerged? Page 37. Let us see the content, page 37.
Lordships. Lordship, that is based on the return file data figures.
Lordship,
That
the-
instruction that I took your Lordships to, the IIT Big Data
Let
software.
me have a look also.
Lordship, I'll place before your Lordships.
Lordship, the brief fact states that in the page page 37, Lordship, simply it's a notice indicating that-
Summary, but let us see page 39 onwards, I think. Is it not?
Lordship,
Yes.
39 onwards, it's the annexure to the DRC. There is no allegation actually.
Mr. Counsel,
Lordships.
this is related to GSTR 01,
Lordships.
GSTR 2A, GSTR 3B.
Lordships.
Why you have not disclosed this?
Lordship, kindly comes to page 29. The audit notice annexure, all these has already been considered in audit.
Let us see.
Lordship, page 29. Page 28 is the audit notice and page 29 is the annexure to the audit. What documents have been submitted in the course of audit? Lordships, reconciliation statement in respect of GSTR 9, GSTR 1,
Where
GSTR
from you are
3.
reading? I am not, you have marked your
No, I
line. I have not marked.
Lordship, I apologize. I apologize.
Somewhere from between you started reading.
Lord, I apologize.
Difficult.
Page 29, Lordships. Once your Lordships are there, then I will.
What is the amount they have claimed in this page 37 notice?
Lordship, page 37, Lordship, the tax amount that they have claimed is on account of GST 15 lakh rupees, on account of cess 45 lakh rupees. Cess is a separate head, Lordship. And Lordship, this was already reconciled in audit. What happens, Lordship, when audit is conducted, they issue a discrepancy memo only for the final, which have not been clarified. But to the extent it is clarified, it is with their records. Therefore, Lordship, in my prayer also, I have written a prayer that records may be called for in that case.
You are on so-called notice only. Don't go into the disputed facts. We are on to examine whether this so-called notice has been properly issued or not properly issued. We are not going into other.
Lordship, whether
You are in a writ petition.
Lordship,
Right?
Lordships,
So-called is otherwise normally ordinary is to be replied.
Lordships,
Right?
Lordships.
Don't cross
Lordships.
the border.
Jurisdiction, Lordship. Lordship.
Only on jurisdiction.
Only on jurisdiction, not on merits.
Nothing.
Nothing
less.
nothing beyond Lordships. I vote out.
We are examining that only.
I vote out to your Lordships.
You take your instruction, under what situation this has resulted. You are from this place?
Lordships, Kolkata.
Okay, when it is convenient for you. Let him take instruction. We will not proceed otherwise.
Lordship, till only that.
We are not satisfied, right? If there is reason for issuance of the other notice, we will not proceed further.
Lordships.
But if we find a primacy case, then we'll proceed further. Yes, Mr. You have to explain this situation. Take your instruction, take your time.
Yes, ma'am.
When?
Lordship, on second.
Second, convenient. By what time it is to be replied, otherwise?
Lordship, the due date to reply is 20th, tomorrow. They give 30 days, Lordship, and the chauffeurs also suffers from other points because they have not given any place of time of hearing. I am not on all those grounds. The due date or to reply is 20th of January, Lordship. That can be seen at page number 28.
You satisfy me on the point, Mr. Chaudhary, on the next date, till that it should not be given effect. Third, Mr. A. Kanodia,
Lordships.
Learned Counsel for the petition. And Mr. Z. B. Chaudhary, Learned Standing Counsel, Finance and Taxation. For all the respondents,
Yes, ma'am.
the confronted with two show cause notices under section 73 within bracket 1 of the Assam
CGST / Assam, both lot.
CGST stroke AGST
Lots.
Act 2007 for the same tax period, April 2008 dash March 2019. Two show cause notices. Roman 1 লিখিব. Show cause notice dated 21/12/2020. Annex Roman 4 and Roman 2. Show cause notice dated 11/1/2020. The petitioner has approached this court on the ground that for the same period there cannot be two such show cause notices. Full stop. The petitioner has contended that the show cause notice dated 11/1/2024 was preceded by a notice for conducting audit dated 21/7/2023 under section 765 of the CGST stroke AGST Act 2017, followed by audit observation under Rule 101 within bracket 4 of the CGST and AGST rules. And audit observation, right? Anything else? Audit observation.
Audit observation.
And whereas the show cause notice, impugned show cause notice dated 21/12/2023 has not been preceded by any kind of notice or any kind of notice. Post office. Issue by Mr. Chaudhary, Learned Standing Counsel, Finance and Taxation Department has submitted that he needs 2 weeks' time to obtain further instructions in the matter. More particularly, under what situation the impugned notice dated 21/12/2024 has been issued to the petitioner for the same period, tax period, that is April 2018 to 2019. Sorry, March 2019. Full stop. As agreed to by the Learned Counsel for the parties, release the case on 2nd of February 2022. It is having regard to the projection made. It is observed that till the next date of listing, there shall not be any coercive action in terms of the impugned notice dated 21/12/2014.
Lordship, just one, Lordship, the instructions which my learned friend will take, Lordship, regarding that instruction number 13, which your Lordship just took, the state of Assam notification, instructions to that extent, Lordship, is also necessitated. Lordship, page 64, that when an audit is completed, no show cause notice, all the show cause has
And
to be.
also in terms of the instruction number 13/2023, that's GST dated
26th.
26/12/2023 within bracket annex Roman 8,
Grateful to.
comma, clause
Lordship, clause one,
One,
clause one, Lordship, clause
clause one.
grateful. to.
Yes, Mr. Goswami.
I have a 1 minute motion, 24.
Okay.
Only notice may be issued
Okay.
and let the government uh, respond.
24.
We are distressed ladies, my lord, took loan.
Any state council? Please call somebody.
We took
Microfinance.
Microfinance, my lord, we took loan.
Okay.
Unfortunately, these ladies couldn't repay. Government has a scheme. We come under that scheme. Some people are getting the benefit. We have not got it. Therefore, we are before your lordship.
I heard Mr. P.K. Goswami, Learned Senior Counsel, assisted by M.S. G. Goswami, Learned Counsel for the petitioners. Okay. You appear on behalf of? B. Gogoi is finance. Okay. Any state council? Well, issue notice, Mr. H. Sharma. Learned Additional Senior Government Advocate, please inform. For the respondent number 1, and Mr.
H. Borua.
H. Borua, Learned Counsel appearing for Mr. B. Gogoi, Learned Standing Counsel, Finance Department for the respondent number 2 and 3. Full stop. The petitioners, 26 in number,
26.
have preferred this writ petition on the premise that they have been unjustly deprived from the benefits under the scheme, quote, Assam Microfinance Incentive and Relief Scheme, page 39. Within bracket AMFIRS, bracket close, 2021. Unquote. Framed and notified by the government, state government, finance department of the state government on 8/11/2021. Full stop. What is your ground of full stop? Mr. Goswami. Mr. Goswami, Senior Counsel appearing for the petitioner has submitted that the petitioners are
eligible under this.
Petitioners fulfill all the eligible conditions
Yes.
laid down in the state scheme,
Yes.
but they have been unjustly deprived merely on the ground that
No ground has been given. They are not
Okay,
considering,
full stop.
the only prayer is that they should
Full stop.
consider and decide.
as so and so can be accepted, no formal notice, extra copies within 2 working days, the petitioner shall take. Who are these other respondents?
They are all part of state and 2 are finance.
Microfinance. Okay.
Microfinance.
The petitioner shall take steps for service
4
of
and
notice
5.
upon the respondent number 4 and 5 by registered post with AD within 3 working days. We issue notice returnable on the depot data.
26/2.
26/2.
This. Sorry for.
Item number 23.
Your Lordship, the petitioner before you is a widow having 4 minor children, and her husband died in the custody of Botodobo Police Station on 21/5/2022.
Police custody?
Yes.
Roaster home যে দিয়ে inside police station?
Yes, Your Lordship.
এই রোস্টার যে সোমবার মঙ্গলবারে যে উলাই যায় এখন custodial date is division bench matter.
I was inquired by the bench. I also told them that it is, but they have listed it here, Your Lordship.
The instant repetition is preferred in respect of custodial date of the petitioner's husband. stating that the petitioner's husband, late Safiqul Islam, died inside Botadrupa police station. Full stop. The office is to ascertain as to whether a writ petition involving custodial debt is a matter pertaining to settlements or the division mates. Thereafter, after ascertaining the same, the case be listed thereafter.
Item number 59.
May I please? Lordship, petitioner approach my lord my lord regarding my lord jurisdictional issue, my lord. My lord, in this case, my lord, everything, my lord, petitioners, my lord, pursued a vehicle, my lord, and loan agreement was also executed at Shipsagar, my lord. The cause of action arises, my lord, here, my lord. My lord, last occasion, my lord, your lordship had passed, my lord, an order, my lord.
Yes, I have passed an order
Lordship. I have annexed
on
the Navin Chandra Majita.
after retrospection that Navin Chandra Majita is regarding police investigation.
Lordship.
Is it not?
Lordship.
Now, here is a case. One criminal proceeding is pending before a judicial forum.
Lordship.
And that forum has issued the summons.
Lordship. Well,
When is your next date?
next date, my lord, that is 24/3, my lord. I have
20?
14/3, my lord.
14/3. Okay, we'll post this matter also on, because I have some doubt now whether Navin Chandra Majita will be applicable or not. What are the other cases? This Basant Kumar Agarwal, and let us see. Sushikant Prasad.
Lordship. That is my lord. Out of it.
In any of the cases which you have relied, was there any proceeding pending in a judicial forum?
In Basant Kumar Agarwal case, my lord, it is, my lord, paragraph 21, my lord. Cause of action arises, my lord, here, my lord.
No, that is regarding FIR. My specific question is whether in any of these cases, because Basant Agarwal, if you come to page para 29, SR has been passed, FIR. Right.
Right.
So far, Sushikant Prasad is concerned, this is regarding Negotiable Instrument Act.
Lordship.
Right.
No.
And cause of action regarding any offense under section 138 have been defined in the act itself.
Right.
And there are a series of judgments
Right.
on that. That because of that cause of action, some amendments have also been carried out in the act. But neither in Navin Chandra, Basant Kumar Agarwal, or Sushikant Prasad, anything regarding a proceeding pending in a judicial court.
Well, similar order, my lord, this honorable court, my lord, same, my lord, complaint case filed before.
I am asking you because of the decision of the Supreme Court.
Majid.
If they, that is, we'll examine the matter again on Wednesday. I have to get hold of the decision to find out whether this is, because in none of the cases, except this interim order perhaps, and this court's interim order. But Nobin Chandra Majita is not deciding anything about any criminal proceeding pending before any judicial court of magistrate.
Even my lord, section 177 CRPC also provides.
That is Mr. Cause of action.
Lordship.
I am specifically asking you, time and again, that show me any decision of the Supreme Court where on exercising powers or jurisdiction under Article 226(2) of the Constitution, a High Court has quashed any criminal proceedings pending in a court of law, which is within the jurisdiction of another High Court. Have you understood?
Yeah.
These are affairs. Nobin Chandra Majita is in case of police investigation. Here you are questioning issuance of summons by a court of Metropolitan Magistrate situated in Calcutta. Is it not?
Yes.
That is the subtle difference. Whether a proceeding pending in a court of law within the territorial jurisdiction of another High Court can be quashed by another High Court simply on the ground that cause of action part of the cause of action has arisen within the jurisdiction of this court. That is the difference. All these judgments, Supreme Court judgments on the criminal side, are in respect of police investigations. Am I clear? Show me any judgment that by exercising power under 226(2), this court can quash criminal proceedings pending in a court of Metropolitan Magistrate within the jurisdiction of Calcutta High Court. These are the differences. When is it? Show me. Otherwise, I have to get hold of it. Because one judgment of the Supreme Court says, after discussing Nobin Chandra Majita, that this is the difference. The proper remedy is to approach the jurisdictional High Court. So, though I have passed the order on the basis of the other previous orders, now I have some doubt. Mr. Ellen Dihingia, Learned Counsel for the petition, has sought for some time to address on the point as to whether this court can have the jurisdiction to quash criminal proceedings pending in the form of a complaint case from a complaint case number in the form of a complaint case pending before a court of metropolitan magistrate, which is within the territorial jurisdiction of another high court. Place the case on Wednesday.
60.
May it please the Lord. My Lord, I request your Lordship to turn to page 16.
Page?
16, 1-6.
1-6.
1-6.
Certificate of winner.
I was elected and I was thereafter, my Lord, because of pandemic, I could not, the board could not conduct the annual general meeting.
You became director.
Director, my Lord.
Okay.
Thereafter, I was elected, became the chairman and president. My Lord, thereafter, because due to pandemic, the annual general meeting could not be held. So under the provision of section 39, my Lord, it was automatically dissolved. And my Lord, then I approached the Honorable High Court. And the High Court passed an order. It starts at page 17. And the operative portion is at page 22, last paragraph. In view of
Yes,
the matter, the
20.
petition should be allowed to hold the AGM for which respondent is directed to give necessary consequently the impugn order.
Page 22.
22 last line, my lord, last paragraph 11. Your Lordship had got it. The petitioner should be allowed to hold the AGM for which the respondent number 5 is directed to give necessary permission. Consequently, the impugn orders dated such and such are hereby set aside. The AGM should be held by the petitioner on or before 15/12/22. So thereafter, my lord, at page 24, Manoj Kumar Sharma, my lord, he took over as a one-man committee, my lord. Your Lordship has got it. Then, my lord, I gave my resignation letter, page 25, that page 26, that due to my personal problem and some unavoidable circumstances, I cannot perform my duty properly as a president chairman of the society. So I resigned from the post on 14 December 2022, page 26, to an affidavit. I resigned from the post.
No, after resolution, what purpose?
My lord,
Say after page 24.
page 24. One-man ad hoc committee took over.
What remains for you?
Then, my lord, because
To issue tender resignation.
Because, my lord, for personal reason, I could not.
No,
Because, my
if
lord,
the one-man committee has taken over,
my lord,
meaning thereby
my lord,
the society board of directors has been dissolved
my lord.
on 19/11/2022.
Hmm.
So what remains for you
My lord,
on 14 December 2022 to tender resignation?
because, my lord, board of directors, which was dissolved by our operation of 39, was set aside. Because
Set aside. Then by this, rightly or
director
wrongly,
was to hold the
no,
AGM,
rightly or wrongly, by page 24 order,
my lord.
that
He was
board has
directed to hold the
again
AGM.
been dissolved.
Dissolved, and he was directed to hold the AGM.
No. That's
Right.
no. Lordship will see, my lord, the word withdraw. The earlier dissolution order has been withdrawn.
Withdrawn.
Huh?
Earlier,
One man has not been appointed. One man has been
Okay.
withdrawn.
No, he is saying.
Yes, correct, my lord.
Read, I have not read.
Yes.
I do hereby withdraw this office.
You have said that one-man committee has been appointed.
The appointment of Manoj Kumar Sharma as one-man ad hoc committee of Dakhin Part.
Like the Jamabandi copy, I have not read,
But I
or
believe
read
that
the order.
I have found it out, my lord.
When in the earlier petition.
My lord, I found it out that it is there. It is there. It is there. Here, that one-man ad hoc committee was withdrawn. Then, my lord, and at page 25, I have given my resignation. My lord, then at page 27, your lordship will find on 2/1/2024, nomination papers will be received on 11/1/24 from 10 AM to 1 PM. The election to be held on 21/1/24.
Page 27.
Election notice.
Yes.
My lord, I filed an application at page 29 to consider my case for my nomination. At page 29, Annexure 6. Then, my lord, at page 32, the Assistant Registrar Cooperative Society wrote a letter to the Register of Cooperative Societies, page 32. That in the meantime, the Honorable High Court issued an order, third paragraph, continue the Board of Directors of such and such. Accordingly, the Board of Directors Society convened the annual agent meeting in time, but the meeting was adjourned due to lack of quorum. Your Lordship has got it? This is for your kind information. The Board of Directors of the Society has resigned from BOD position before the adjourned meeting could convey again. Hence, the
Who
management
board
also-
of directors? You only or
other
all?
members. Board of Directors along with the other members. madam.
All have resigned.
No, only I have resigned.
Only you have resigned.
Only I have resigned. Your Lordship may read it that it is for information, the Board of Directors has resigned from the position, the adjourned meeting could convey again. Hence,
You
the
and the
management-
chairman has resigned.
The chairman has resigned, madam. And now-
Others are continuing.
continuing, my lord. Then, my lord, at page 33, I have deposited my nomination fees and others. 33 and 34. At page 35, my lord, nomination paper of the election board. And now, my lord, at page 37 is the impugn order. Serial number 9. Ismail Hussain, Director, ineligible as per section 44A and E of the Cooperative Society Act. Now I have been prohibited to file my nomination.
This has been cancelled by whom? Election official.
Election officer.
Then
My lord, this is the impugn order for which I am before your lordship.
I think there is a set of rules, perhaps.
My lord, because here in my case is this, my lord.
Your case is non-acceptance of your nomination paper, declaring it as you as ineligible.
Ineligible under that 40, but I say.
When this order was passed?
It was passed on, my lord, 12-1.
12-1.
12-1, there
I think there is a provision for appeal.
That's Rule 27.
Huh?
Rule 27.
Rule 27.
My lord,
Rule was rule
My lord, I filed my representation before that. Before deciding that, my lord, they will hold the election. Because it is not that I have not filed an application, my lord. It is, your lordship may find it is pending before that. Page 29.
Which rule?
27. my lord.
Regarding a rejection of ballot paper or nomination paper, is there any provision?
Only thing is
There
the
is-
election authority shall
There
make
is
an
no-
inquiry.
There is no separate provision, my lord. But if your lordship goes by that Act of 51, that my lord, rules, conduct election rules, my lord, that improper rejection, not this one, my lord, but under the Representation of People's Act, my lord, perhaps section 100, that improper rejection, my lord, is an election dispute. Improper rejection of nomination, my lord.
No, it appears from also this one also.
Rule 27.
27 also.
Yes.
The election authority shall make an inquiry upon the dispute on the basis of relevant record and first necessary order. 27B.
What is the provision regarding nomination papers in these rules?
There are provisions, my lord. Your lordship will find. It starts from, my lord, Rule 6, filling and scrutiny of nomination papers. Essentially, it starts from Rule 4, from appointment of returning officer.
Yes. And nomination scrutiny.
Yes, my lord. Rule 6.
it was declared on the same day.
Rule 7B, my lord.
Rule 7.
B. So under this provision, my lord, it has been, the nomination paper has been held to be, or he has been held to be, my lord, not eligible.
Disqualified.
If he is otherwise disqualified, it is under provisions of the plan.
It is under section 40 for not
40.
holding
What is
the,
section 40?
not holding the AGM. And what appears, my lord, his affidavit, my lord, it is to the extent, my lord, that as a president of the board, I had resigned. So meaning thereby that he was still the member of the board of directors. He was still the member. He only resigned from the president's seat, my lord. So that ipso facto, my lord, will not exonerate him from being disqualified.
Because, Board of Directors
Yes.
was allowed to continue.
No, in fact, my lord, what has happened?
That one-man management committee was withdrawn.
Withdrawn. My lord, Honorable Court directed that during the COVID period, you could not hold the AGM. Now you hold the AGM by 15/12/22.
15/12.
15/12/22. Apparently on that date, my lord, the AGM could not be held due to want of quorum. And what the projection of the case is, my lord, that before 15/12, on 14th, my lord, he resigned as the chairman. That is the case, my lord. Nothing else.
Then 14/12 you resign
As the president.
as the president. Then 15/12 AGM could not be held.
My lord, my only case is this, my lord, I may be allowed to participate, nothing more.
No. You are the only one who has been declared ineligible.
My only one.
Others did not apply. Others did not apply. Your lordship will see, my lord, even there are not 15 numbers of nomination papers. What I find, my lord.
22.
22.
22 nomination papers.
Oh, sorry, my lord.
22.
Enough nomination papers. Except him,
Yes.
nobody has been declared ineligible.
22.
Now, a democratic process of election, just because of the petitioners cannot be derailed. But how you can be declared because you did not run the race till the end.
Because it was 11th and from 12th, it was a holiday. And on that day only, it was.
You tried to be too smart.
But my lord,
You
it
withdrawn
was,
for a race, thinking that others, they would be failing to hold the election on 15/12, they would be disqualified, you will be the only one who will be eligible. But things turned out to be different.
if their AGM could not be held, the other person should also be disqualified.
No, my lord, this is not the case. That
This
the
is not-
others are allowed. I am only, my lord, singled out. That is not the case.
But
my
it
lord.
is shown as
Is
eligible.
anybody from that board of directors have submitted any nomination paper?
No statement to that effect, my lord.
But it has been shown from page 38.
No, page 13 was statement.
Boido, my lord.
We are not going to examine who are the board of directors. Is there any statement from the earlier board of directors? They have been allowed?
No, my lord, as such, there is no, there is no such statement.
Nobody applied earlier board.
They knew.
It's not that I'm asking for a stall of the election.
No.
The only thing is that if I can be participated, man. Because I filed an application also, it was pending before the raised. As raised.
No, you have directly come. Have you made any application before the register?
Yes, there is an application.
Huh?
Before I submitted my form, I filed an
No,
application.
before submitting the form, no, after cancellation of this order. When it was
Cancel-
passed,
It was passed on the 11th, my lord.
11, we are on 19th, 19th.
Then it was a holiday, I came directly over. It is 19th. Yesterday I filed it
11th.
and today is the case. And 21st is the election. ma'am.
Cannot be, we are not very satisfied.
No.
And not at least the interim order you are seeking, that state the AGM election for the year so
No,
and
no,
so.
I'm not asking for a stay.
That is the specific prayer you have made.
That is too bad. Your lordship can definitely mold in 226. That
Not very
is not that
satisfied.
what I have written, it will be taken into consideration.
Not satisfied, Mr. Vachuri.
Because others has been shown as a boido, my lord. They are also the board of directors member, my lord.
Who is statement?
But it document shows, my lord.
I am not, Mr.
Document shows they are
Vachuri,
showing
I am not
religious, my lord.
looking that Abdul Samad, Abdul Rahman were the members of the earlier board of directors.
Your lordship will look into page 37. They are the directors.
Mr. P.K. Vachuri.
They are the directors, man.
And Mr. S.K. Alota. Who is a statement? Read petition is to be decided on the basis of statements and averments.
Only thing is the direction, they are from
Planning Council, Corporation Department for the respondent number 1 to 5.
Because in some cases, my lord, orders have been passed. I have annexed those documents. I have orders copies, my lord.
What is 42?
Page 42.
No, section 40. Under what provision, Mr. Talder? He was
Some of the directions.
My lord, 40, section 40, my lord.
40.
Subsection
4A and 4A and
40?
40A, my lord.
4A.
44A. Not conducting or wrongly conducting.
Let him participate then, subject to the outcome. His results should not be declared.
that will be that much will
I
be.
leave it to lordship. I have nothing to say.
Heard, Ms. Swains. The petitioner was earlier elected as one of the directors in the board of directors of Messrs. Dokhin Titapani Homobai Limited, Borpeta, a cooperative society registered under the provisions of the Assam Cooperative Societies Act, 2007 in the election stroke annual general meeting held on 23/9/2018. Full stop. The AGM for a year 2000, which year? Cooperative year.
Cooperative year, my lord, it would be
For the
24 to 29, 24, 25, 26, 27, 28, 24 to 28. From this year to up to 28, my lord, 5 years.
5 years he could not hold. 5 years?
No.
What, my lord?
I was elected in 2018, man.
This page 20 judgment covers AGM of which year?
Oh, AGM, my lord. Yes. AGM of 22, my lord.
Okay. AGM of the society for the cooperative year 2021, that's 2022. Was scheduled or could not be held due to COVID-19 pandemic and other ancillary issues. Post op. When a repetition was prepared by the petitioner and other members of the board of directors. Repetition, assailing, WBC number 7135/2022, comma. The said repetition was disposed of by an order dated 11/11/2022. With direction to the respondent authorities to allow the petitioners to hold the AGM of the society on or before 15/12/2022. Full stop. Accordingly, the one-man management committee who was entrusted the task to hold the AGM, was withdrawn with effect from 19/11/2022. Full stop. It was on 14/12/2022, that is one day prior to the AGM scheduled on 15/12/2022, the petitioner tendered his resignation from the post of chairman of the board of directors of the society, but continued as a director in the said board of directors of the society. Full stop. Finally, a notice regarding the election stroke annual general meeting of the society has been scheduled on 21/1/2024 by a notice dated 2/1/2024. Full stop. In response to the said notice, the petitioner submitted his nomination papers to contest the election, but the election authority has rejected the nomination of the petitioner on the ground that the petitioner is found ineligible because of his failure to hold the annual general meeting AGM of the society. Petitioner as a part of the board of directors of the society has failed to hold the AGM of the society in compliance with the provisions of section 40 of the Act of the Assam Cooperative Society Act 2007. Mr. Roychoudhury, counsel for the petition, has submitted that, has categorically asserted that the other directors of the same board of directors of the society, of which the petitioner was a part before tendering his resignation on 14/12/2022. Some or all.
The vernacular from page
I am
30.
making there is no statement in the entire petition. If I
That I
find,
understand.
then
I understand. I'm sorry for that. I understand.
it'll be debarred for life.
Well, I understand, but
Have been allowed to submit their nomination papers, and their nomination papers have also been accepted. Full stop. Mr. Talukdar and its standing officer cooperation department has submitted that the same, there is no whisper as regards the contention that some of the members, some of the directors of the earlier board of directors of the society have been allowed to contest the election scheduled on 21/1/2024.
My lord, only one submission.
Huh?
Instead of, my lord, keeping it pending, because eventually it is the election authority who will decide. So lordship may dispose it of, his election may not be declared. Under Rule 27, he will file an application. Thereafter, the registrar will decide and allow him, my lord. If
No,
my
that
lord,
matter may be examined by the
Yes,
election authority itself by tomorrow.
Yes, that can be also done, my lord. I have no objection.
If that statement is correct, he will examine if that is so. He may
Yes, that is.
take a decision on it.
Yes. That can be done, but under Rule
But if he
20
takes the decision against the petitioner again,
yes,
end of the road for him
he has to.
for
take
next
the-
5 years.
That
Yes.
was subject to, my lord, subject to our outcome
Okay.
of this.
And having issue notice returnable on so and so, having regard to the projections, having regard to the categorical assertion made, comma, the court accepting the statement made by Mr. Roy Churi, Learned Counsel for Petition, that some of the directors of the earlier board of directors of the society have been allowed to contest the election scheduled on 21/1/2024. It is observed from in the interim that the petitioner the petitioner should be allowed, the election authority should allow the petitioner to contest the election of the society scheduled on 21/1/2024, comma, after accepting the nomination paper with a rider that the result of the petition selection will be declared without the leave of the court.
Can I make a small prayer, my lord?
That's all.
My friend can inform them that, my lord.
Ah. Mr. Talukdar, Learned Training Council, Proportion Department shall convey, shall take necessary steps for compliance of this order to the appropriate authorities, including the response number 5.
92.
Yes. During the course of the day.
My lord, today I'll inform my respondent 5.
61.
My lord, it should be 4, my lord.
4.
Yes.
4.
It is resistant register.
I thought that was 61.
It is further clear that the petitioner's eligibility to contest the election will be subject to the outcome of the election.
Yes, may it please your lordship. Lordship, it's a matter of eviction, lordship, and land is selling surplus land.
Madam,
Yes, lordship. The petitioner is living there on for long back, lordship, and now not.
I cannot take a view different from what has been observed in page 80.
Yes, lordship. Page
80.
Page 80. Yes, lordship. That time, lordship, notice was not.
Please, no.
Yes.
Please read the penultimate paragraph.
Yes, lordship.
What was your prayer? What was the observation made?
This observation was.
The respondent shall not evict the petitioner from the plot of land under her occupation. This is your petition?
Yes, lordship. Yes.
Without serving prior
Notice.
notice in writing upon her.
Yes.
Now come to page 84.
Now,
By what manner this is in not compliance with the settlement rules?
yes, lordship, there, my submission is that this petitioner.
All these have been gone into.
Yes,
All these have been gone into.
yes, lordship.
there is nothing to find fault with this notice. This notice is clearly in conformity with the direction made by this court
Yes, Lordship.
in the previous writ petition.
My humble submission before you is, Lordship, this petitioner is, your Lordship may kindly see the surname. This is Patiri, a missing community.
No, no,
Yes,
that,
Lord.
all these have been gone into.
Yes, Lord.
You are,
The indigenous people of the
you
land.
cannot re-hesitate the same thing. You accepted this position.
Yes.
And this, there is nothing to find fault with this notice now.
Yes, Lord. I am controlled.
Is it not?
Yes, Lordship.
So how can we save you? We are also bound by the observation made by the
This petitioners are in a.
coordinate
position-
bench,
Yes.
right? You have accepted the position that attained finality,
Yes.
and this notice is completely hard, MS. Yes, MS Sharma, and that's falling from this honorable court, my lord. If you want to save the lady, then you also go to para 16. Para 16. Something more. Oh, you have received 15 lakhs also.
Compensation given, Lordship. the
15 lakhs.
Earlier,
Hard.
15 lakhs, Lordship, 10 lakhs. Earlier, they have completely broken the house of the petitioner.
Oh, it is not the first time.
Yes, Lordship, I have stated in
Oh,
my.
received money also.
Lordship, yes, I have.
Hard. MSB Talukar. Landed counsel for the petitioner. And
Lordship, may I kindly submit you that the land is not government land and it is not fall under Sinsaku bill also, Lordship. It is adjacent land of Sinsaku.
still, is it your case that it is not a government land?
Yes, Lordship, the ceilings are,
Where is that?
I have stated in my paragraph, Lordship.
Madam,
Yes, Lord.
page 80, according to the petitioner, you made an online application for settlement of land, meaning thereby it is a government land.
Ceiling surplus land.
Don't try to twist here and there. Your space. Revenue? Z. Hazurika, why you are sitting in the corner? Standing also revenue and disaster management department 1. S. Sharma.
2 and
Junior
4.
Government Advocate Assam for response number 2 and 4. Mr. S. Bora, Lion Standing Council GMD for the response number 3 and 5. The petitioner has preferred the instant petition to assail a notice dated 11/1/2024 issued served by upon the petitioner under the hand issued under the hand of the respondent number 4, whereby the petitioner has been asked to vacate from the plot of land indicated therein within a period of 15 days. On the ground that the petitioner is in unauthorized occupation of the land indicated therein, full stop. Issue notice returnable in 4 weeks. So the petitioner has also sought for an interim relief. Full stop. It is noticed that the petitioner had on an earlier occasion prepared a writ petition, WBC number 5315/2023. The said writ petition was disposed of by an order dated
Pending,
39.
Lordship, this case is pending. This case is also pending.
In the said writ petition, this court, while issuing notice, had observed that the respondent authority shall not evict the petitioner from the plot of land under her occupation without serving prior notice in writing upon her. Full stop. The petitioner has stated that on an earlier occasion, an eviction process was undertaken and some part of the property of some part of the structures standing on the said plot of land were demolished, and the petition received. Full stop. The petition has further stated that the petitioner has received an amount of rupees 5 lakh in respect of the Assam type house and an amount of rupees 10 lakh in respect of an RCC
10
house.
lakhs is not given, Lordship, only 5 lakhs given.
Huh?
Sorry, Lordship, it is RCC house, so 10 lakhs is given. RCC house, so 10 lakhs.
You have said
Yes, Lordship.
standing on the said plot of land. Full stop. On perusal of the impugn notice dated 11/1/2024, it appears prima facie that the procedure required to be complied under Rule 18 of the settlement rules framed under some Land and Revenue Regulation 1886 are complied with. Also, it is not in dispute also that the plot of land the petitioner is stated to be in petitioner is alleged is stated to be alleged unauthorized occupation is a government plot of land, and as such, this court is not persuaded to pass any interim order staying the operation of the impugn notice dated 11/1/2000. Baki steps can put you extra copies.
Item number 62.
How much they have received?
Similar matter, Lordship.
How much
Identical,
money
my lord,
received?
15 lakhs.
Huh?
15 lakhs, my lord. 5 lakhs
5 lakhs,
for,
5 lakhs, 2,
Okay.
10 lakhs, 5 lakhs is Lordship.
for the Assam type house and 10 lakhs for the RCC. And page 86, my lord, this writ petition was disposed of.
Yes, this was disposed of.
Disposal.
Yes,
Yes, my lord, page 88.
Okay. How many petitioners?
2 petitioners.
Okay. 2 petitioners, huh? Petitioners. Impugn notice 11/1/2024. Impugn notices, right?
Yes, Lordship, notices.
Oh, notices. Bottom paragraph. Huh? Parties are same?
Yes, same. Yes, Lordship.
Parties are same. So respond number 7 applicability. Earlier repetition. WBC number 5692/2023, which was disposed of applicable. Notice no, which was disposed of. By an order dated 27/9/2023. So the operative part of the order dated 27/9/2023 reads as under page 87 or 88. This is clearly laid down now.
Yes, Lordship.
15 days notice,
Yes,
you vacate.
But where to go,
Upon
Lord?
receipt of such notice, the petitioner to vacate the land. Again, interim relief, decline. Issue notice, returnable 4 weeks.
Like,
Kuntu? That too, he is not here. But this requires something. When is it? Mr. R.S. Mitchell on council board of petition.
Lordship wanted to know whether application is required to be filed along with the
appeal if there is a delay. Lordship, I didn't find any direct judgment, but in one.
But Mr. Mishra has come up,
Lordship, in one judgment.
Mr. Mishra has come up with one Supreme Court judgment, Seshnath Singh,
Lordship, in one judgment of.
very recent judgment, 2021.
Yes, 22. Here.
Even if,
Lordship, in paragraph 12 of that judgment, this application preferred an appeal before the SAT against the aforesaid order, along with the application for condemnation of delay. SAT on so-and-so dismissed the application for condemnation of delay.
why is it, it's a finance sector.
But in the Finance Act, Lordship, specifically nothing has been.
No, there are two things.
Lordship.
If you read the normal limitation period, it can be presented. If it is within the extended period of limitation, see the word,
Lordship, in my humble submission.
where is that rule, section?
85, my lord.
85. 85.
85.
3A.
3A, my lord. 3A, lord. And appeal shall be.
See that proviso, this authority
Commissioner
has to get himself satisfied
the appellant was prevented by sufficient cause.
on his own.
Lordship, in my humble submission.
Whether there is sufficient cause or not, then this satisfaction should precede the permission to present the appeal.
Allow the present the appeal within further period of 1 month.
I think he is not exercising that discretion.
No, Lordship, in my humble submission, unless the ground is placed before the authority, on which how you can
That
come to
is-
satisfaction, Lordship.
Yes, after extended or expiry of extended period, law is settled.
No, that is there. Even
Law is settled. Now, within that extended period of limitation, law is not settled.
but the Lordship, the
Law is not settled.
yes, Lordship. But here was
Two
prevented
questions.
by
One is whether one thing that is also settled, that the memorandum appeal may not be accompanied by an application for condemnation of delay. That can be filed later on also.
Yes, yes, that can be filed. But Lordship.
Now, the discussion is with the commissioner
Commission to decide,
to decide.
to see
And
whether.
this judgment says that not in all cases an application for condemnation of delay is required to be filed. So these are gray areas.
Lordship,
If you come up with some authority, otherwise I'm
application
issuing
is,
notice, will decide.
Lordship may decide because
We have to
I didn't
decide.
find any direct judgment. But indirect, the application, appeal must be accompanied by the application for, because sufficient cause they have to show.
And he has also misinterpreted that judgment.
No, that,
Is it not?
that is correct, Lord. That I am not disputing.
That cognizance for extension of limitation.
That by Supreme
He has misinterpreted.
Lordship may remand the matter, they will come in.
No, no, we'll decide. Same thing will come up. No solution will be there. Heard Mr. R.S. Mishra, Learned Counsel for the petition, and Mr. S. C. Kal, Learned Standing Counsel GST for the responder 2 and 4.
Lordship.
Over the others,
One is.
anybody, central government, 2 to 4, 2 to 4. Also heard.
RKD Chaudhary. RKD.
No central government council here. PK, Medhi, Learned Central Government Council for the respond number 1. Full stop. Agora order 2 to 4 which is 5. 2 to 5 लिख दियो. Repeat for you. Mr. Mishra, Learned Counsel for a petitioner relying on a decision of the Honorable Supreme Court of India in Seshnath Singh and another versus Boydavati, Seorapuli Property Bank Limited, and another from a report in AIR 2021 SC 2637 has submitted that delay can be condoned irrespective of whether there is any formal application, if there are sufficient materials on record disclosing sufficient cause for a delay. Full stop. It is submitted by, he has further submitted that continuance of COVID-19 pandemic itself is the sufficient cause for condonation of delay. Full stop. No matter return further examination, issue notice returnable on 13/2/2023. As Mr. Cal, Methi and Cal, no formal notice. The it is having regard to the position made, it is observed that till the next date of listing, there shall not be any coercive action against the petitioner on the basis of the impugned order in appeal dated 22/5/2023.
Item number 17.
Page 19, my lord.
Page 19, last one,
Last paragraph.
last,
Yes.
19, last,
চক্র
right
বিষয়ের
hand side.
26/2/2022 তারিখৰ
Last
নামজাৰি-
one, last one.
Last paragraph. হুকুম মৰ্মে ৭৬ নম্বৰ ডাগৰ মাটি উত্তৰাধিকাৰী দখল সূত্ৰে
Where is the notice?
My lord, the notice is at page 20, annexure 3.
Now, where is the statement that this man is receiving, Jalaluddin is receiving notice, compensation?
My lord,
He has been
my lord, my only case is
made the
that,
beneficiary, but the amount has not been dispersed.
my lord,
Is there any statement?
my lord, my only case is this, my lord, they are trying to give the beneficiary to the
That
other,
is what I am asking. Where is the statement?
my lord,
Because your repetition always lacks the statement.
my lord.
There's a title suit also
Title suit pending and a written objection is there, my lord.
against respondent number 6.
Where is the statement? If money has already been gone out,
Lord, your lordship may.
there is no.
Your lordship may issue notice at this moment that much.
There's no statement.
Only issue notice only then. Pick your response. Petitioners have preferred this petition, claiming that they are persons interested to receive compensation in respect of a plot of land measure,
One bigger, one cut, 13 lesser.
measuring in respect of a plot or a part of the plot of land. Measuring.
Page-
1 bigha, 1 katha. 13 lessons
13 lesser,
covered by DAG number 76
76. Periodic.
and patta number 158, comma, which has been acquired by the respondent authorities under the Ahom Mala project. So stuff. It is the case of the petitioner that a title suit
Paragraph 7.
between the petitioners and the respondent number 6 in the form of title suit number
Para 7, 120.
120 stroke 2022 is presently pending before the Court of Learned Civil Judge Junior Division Jai Shankar Nagar, wherein the issue involved is declaration of right title and confirmation of possession against the respondent number 6. Full stop. But without confirming the claim of the petitioner. The respondent authorities have proceeded to have gone ahead by identifying the respondent number 7 as the person interested to receive compensation in respect of the subject lot. Most of the petitioners have asserted that their names are included in the Jamabandi pursuant to the mutation order dated 26/2/2022 in respect of the subject of those we issue notice returnable in 4 weeks as okay. This G Hazarika 1, S Sharma 2345.
Registered.
The petition shall take steps for service of notice. On the respondent number 6 by registered proceed within 3 working days. Issue notice returnable. Any application is pending before Deputy
No, no.
Commissioner? It is observed that pendency of the writ petition shall not be a bar for the respondent authorities, more particularly the respondent number 6.
Page
to-
24.
sorry,
Page
Respondent number 2.
Two.
To examine the claim of the petitioner in terms of the representation
Page 24.
stated to have been submitted by the petitioner before him on 9/11/2023.
Order stating item number 25 with 65.
My lord, here is a case, my lord, where
Bank guarantee.
bank guarantee. Now, the other day, lordship asked them to file an affidavit and to bring on record the relevant clauses. If a lordship
Okay.
could kindly have that,
It is in the IA or in the WPC?
in the WPC. No, my lord, they have filed an additional affidavit.
In the IA?
Yes, in the writ petition.
In the writ petition.
Yes.
Some format.
Yes, yes. My lord will kindly come to page number 193.
Yes.
This is the relevant clause 4.4. For due and procedural punctual performance of his obligation under this agreement relating to the project, the solar power developer has delivered to APDCL simultaneously with execution of this agreement an irrevocable and unconditional bank guarantee from a scheduled bank acceptable to APDCL for an amount of rupees so and so, so and so. The performance securities furnished to APDCL in the form of 3 bank guarantees in favor of Chief General Manager, Commercial and EE of APDCL as per the format provided in Schedule 3. Kindly mark that point. And having validity up to 22 months from the date of signing of the PPA, that is Power Purchase Agreement. So, my lord, this is the requirement. Now, my lord will kindly come to page 228.
Mr. Bank is available or not?
Mr. Bank. Here some time ago.
Because
Mr. Bank is finally emerged. My lord will kindly come to 228.
okay.
Now, this is Schedule 3. Now, nowhere it is prescribed that beyond, my lord, period of expiry, they will have the, when they can invoke it.
Okay, let us go back to the bank guarantee submitted by you.
Yes. For that, lordship will kindly take the writ petition.
First, my lord will kindly allow me to place that letter of award at page 76.
No, just have I'll just, because the other file is open,
Yes.
so just I'll compare.
Yes.
It will repetition. WBC 228. It is in a repetition, sir. 228.
No, my lord, 6446.
We are in 6446.
Yes.
This, the banker submitted by you is part of the repetition also.
Yes.
Let us see.
Page 17. My
Page?
lord will kindly come to page 76 first. This is the letter of award. On 4th of January 2021. With reference to a response against RES mentioned above, we are pleased to inform you that tariff quoted of ₹3.99 only per unit for development of 25 megawatt grid, etc., as specified in RFS has been accepted and you are declared as a successful bidder. And my lord will kindly come to 2B. In terms of RFS and PPA, performance guarantee of rupees so and so, in all 4 crore 22 lakhs, 20 lakhs. Now please come to Roman 1. Performance bank guarantee for an amount of rupees 84 lakhs, having validity up to 22 months from the date of signing of the PPA, that is 15/2/21. Similar are the prescription in respect of 2 and 3. Now the bank guarantees, my lord, at page 80. They also proclaim that it is under Schedule 3. Please come to B. In terms of Article 4.4 of the agreement, solar power developer is required to furnish to APDCL an unconditional and irrevocable.
This was submitted by the bank
at
your instance.
Yes, it was between bank and the APDCL.
You are supposed to submit the bank guarantee in form of Schedule 3.
Yes.
So that is the
understanding.
That is the understanding.
Yes. Now, my lord, where from this at page 82 3 comes?
Right, that is why I asked the question.
That means it is
that
fraud.
at the time of issuance of the bank guarantee, you have got the delivery from the bank and carried it to the office of the APDCL and deposited it.
Yes, that's
right.
That's an instrument.
Right. So at the time of issuance of the bank guarantee, there was no role on the part of the APDCL to incorporate this clause.
Yes.
Right.
Nobody,
where from this has come?
In fact, nobody is mandated to incorporate this.
Right. Where from this has come? That is what the
Behind
question
my
is.
back, naturally.
No, behind your back at the time of issuance.
Yes.
But from the point of taking delivery to delivery to the office of the APDCL to execute the PPA, it was within your knowledge.
Yes.
Now, where from this has emerged?
They will have to explain that, my lord.
APDCL is also, because how this has come, there might be some answer, but it is better to have an interaction with Mr. Sharma.
And my lord, I'll just also today we have filed a small affidavit. Sitting on court. Yes. I think it is on record. Yes. My lord will kindly come to this. Starts at page number 235.
Right.
Small affidavit. আমি তো বিচাৰিছিলো। It starts at page 235, my lord.
235. There's 235. Huh? Okay, two. Okay.
Today, yes. Please come to page 239, my lord. This was our request to the bank. Application for issuance of bank guarantee. We request you to issue 3 number of performance bank guarantee in favor of Chief General Manager so and so for the details mentioned below. So, my lord, as far as we are concerned, we are absolutely clear.
No, that is what if I'm not wrong, that has what had happened.
Yes. One more thing, my lord, before my learned friend stands up. My lord, the lordship knows in case of invocation of a bank guarantee, the employer is within their right to invoke it, and normally lordships will not interfere. There are only two situations Supreme Court says lordships can interfere: irretrievable loss and fraud.
Fraud.
Yes. So for that, I'm relying on authority, my lord. I continue.
No, my query is to the core,
Yes.
to the council,
Yes.
is that
Yes.
this bank guarantee can have a validity period.
Yes. And which
There is no doubt about it.
Yes.
Now, whether a bank guarantee can have a claim period other than the validity period,
Yes.
That this incorporation and whether, how this has come.
Now, APDCL has tried to justify it by saying it's a normal banking practice. Better it is for them to, onus is upon them. They have taken a stand in their affidavit that it is a normal banking practice.
otherwise, I had dealt on
Well, on
just
my
other
behalf-
bank guarantees.
There is an
Yes,
outer limit.
there is a validity period. Then
Huh.
this regarding this claim,
Huh.
there is another period.
Well, yes.
I have found in some, I don't know the region. I don't know the region, but I have found that in bank guarantees, there are claim period other than beyond the validity period. I don't know the region, but I have seen.
No, my lord, my humble understanding is clause 4.4. Read with schedule 3. I think we are to confine ourselves to that.
Right. But
In order to assert any right.
who has incorporated? It appears to be bank. Just I'll
Yes.
find out from Mr. Sharma. Then I'll hear you. Mr. Sharma, whether a bank guarantee can have a validity period and a different claim period, or the validity period and the claim period of a bank guarantee should be one and the same. Where from this concept has come? No. No. You read and read and read. This is not clause section 28. Subsection 3. No. That has been incorporated. That is a defined one.
Earlier it was 3 months. 1 year from the date of validity.
Where from? Read section 28(3).
Yes, sir. That this section shall not render illegal a contract in writing by which any bank or financial institution stipulates a term in a guarantee or in any agreement making a provision for guarantee for extinguishment of the right or discharge of any party thereto from any liability under or in respect of such guarantee or agreement on the expiry of the specified period, which is not less than 1 year from the date of occurring and non-occurring of the specified event for extinguishment or discharge of such party from the same. I have not gone to the one website is also relied on. Just it called Judgment Union of India.
See the substantive provision. This has to be read with the substantive part of section 28. This is agreements in restraint of legal proceedings. Void. Legal proceedings.
An exception on the part of the bank.
That is for a particular reason. For the purpose of understanding incorporation of this amendment, you have to go to the statement and objects. Because in case of
Now, where is the concept that validity period and claim period can be different? Because it appears this incorporation of that particular claim period is neither in Schedule 3 nor has been asked for by the petitioner. Do you have the copy of the bank guarantee?
Yes.
Please have a look at page 80. Page 80. 82 is the legal part.
82 is the, we are liable to pay the guarantee amount only and only if we receive from you at our address indicated below a written complaint or demand no later than 1 year from the date expiry date.
Right. Now expiry date is 1/2023. Failing which all your rights under this guarantee shall extinguish and we shall stand completely discharged. Right. There is no mention about section 28. Section 28 is with regard to legal proceeding.
Earlier it was 3 months and then later on it has been made to 1 year.
Section 28 is in respect of legal proceedings.
It's legal. But this is an agreement between me and the APD. And my charges has to be paid.
Now read section 28 first. Without that, you cannot read an exception.
Yes.
Read
Every agreement
by which
by which any party thereto restricted absolutely
from enforcing
his right under or in respect of any contract
by the usual legal proceedings, normal court,
in the
or in the ordinary tribunals.
Yes. Or which limits the time within which he may thus enforce his right.
So that is regarding legal proceeding.
Legal.
Clause A. Now clause B.
Yes. Which extinguishes the right of any party thereto or discharges any party thereto from any liability under or in respect of any contract on the expiry of the specified date, so as to restrict any party from enforcing his right is void to that extent. If the time limit will not be there.
Is void to that extent, which extinguishes the rights of any party thereto. Now, where from this 1 year claim period? There has to be some basis.
There has to be some enabling provision.
Something that, yes, in case of, say, suppose, I'm hypothetically, for 1 crore bank guarantee, it is 6 months, 2 crore bank guarantee, it is 9 months, like that, some laid down norms.
In other words, this exercise of power must be traceable to some legitimate source.
Because this has been created by you only.
Yes. I have got only 2 judgments and this one IBA's notification.
IBA, let us see.
That is not received. That today only I have received the mail from the bank.
Okay, yes, send it to the court master. Let us have a look, all Mr. Chaudhary and Mr. Pathak. Otherwise, this is the issue only.
Yes.
If it is traceable to something in the banking norms, we'll hear you. Let us find out, then it would be better for you to address it on it. If that is somewhere connected with something. Otherwise, we are not aware where from this. If this claim period of 1 year remains, you have a case. If it does not remain, Mr. Chaudhary will have a case. What? That is another aspect. So we are trying to find out from the enabling provision. Otherwise, law is well settled regarding bank guarantee. There is no doubt about it. These two exceptions, I don't think irretrievable injury of that
And fraud.
fraud, scan, or that something which is very difficult to pronounce. Some American bank, Colombia and all this. What is the Scandentine, something like that?
Yes.
Is it not?
Yes, my lord.
Very difficult to pronounce. Svenska Handelsbanken.
Some Spanish name, I think.
That is bank guarantee given by Iranian court to the America.
Yeah.
American bank. Is it not?
Yes.
That tell me. Have you sent? What I said? Huh? Indian Bank Association.
Indian Bank Association, one writing has been given to me by the bank.
Okay.
But I have not gone through fully that.
Okay, read so that everybody can.
And cannot force debtors to have a compulsory claim period of 1 year under the contract of bank guarantee. This is a significant development in interpreting exception 3 to section 58 of the contract act. Thereafter, under the bank guarantee law in India, while holding court, the High Court stated that the circular issued by the Indian Bank advising its member banks to have a mandatory claim period of 1 year in bank guarantee are dictated in the backdrop of exception 3 to section 28 of the IC. One of the largest construction companies in India, Larsen and Toubro Limited, filed a writ petition challenging the misinterpretation of exception 3 to section 28 of the IC. While the respondent bank has sought a writ of certiorari against the erroneous interpretation of state exception in circular dated 10 to 2017 and 05/12/2018 by the IBA. By way of this circular, the IBA had advised its member bank that it would be open for the bank to fix the condition precedent under the contract of guarantee that if the claim is not lodged before a stipulated time, the bank guarantee shall be revoked or terminated, but such time cannot be less than 1 year in any.
You are reading third paragraph?
Yes, sir.
Okay.
Third paragraph, last paragraph. The IBA further advised that if the bank issues bank guarantee with a claim period of less than 1 year, then such a bank guarantee would not have the benefit of exception 3 and would stand exposed to the period of limitation under the Limitation Act 1960. The fourth paragraph. It was contended by the petitioner that under the misinterpretation of exception 3, the bank insisted that the claim period, a contractually agreed grace period beyond the validity period of bank guarantee, to make a demand to the bank against the default which had occurred during the validity period, should be not less than 1. The petitioner argued that exception 3 typically governs the enforcement period, under which the creditor can enforce his accrued right before a competent court of law pursuant to a demand being made by him.
This is my understanding also of exception 3. Okay, let us see.
Within the validity period or the claim period. Therefore, it was the case of the petitioner that the bank cannot force the debtor or the creditor to stipulate a claim period to be not less than 1. The respondent asserted that exception 3 entitles the bank to to insist on a claim period of 1 year in the bank guarantee. They also relied on the judgment of the Supreme Court in Union of India versus IndusInd Bank, where the court dealt with the question of retrospectivity of section 28B of IC. While holding that the state section 28B being a substantive remedial law will operate prospectively, the Supreme Court also observed the stipulation in Sangam. The court observed that clauses such as unless a demand or claim under the guarantee is made within 3 months from the date of expiry of the guarantee, all the rights of the beneficiary shall be forfeited and the bank shall be relieved and discharged from all liability. In bank guarantee would pass the muster after addition of exception 3 in the year of 2006. If the specified period is not less than 1, the respondent heavily relied upon the aforesaid orbital dictum of the Supreme Court and contended that the bank have a right to insist on a claim period of 1 year in the bank. The single judge of the Delhi High Court rejected the contention of the respondent bank and held that it is an erroneous view that they are legally entitled to establish a claim period of 12 months in the bank guarantee, telling which the clause shall be void under section 28 of the Act. The High Court noted that section 28 of the IC stipulates that every agreement by which any party is restricted absolutely from enforcing its rights under any contract, or which limits the time within which the right can be enforced, or which extinguishes the right of any party or discharge any party from any liability or expiry of a specified period to restrict any party from enforcing his right is what the state section essentially prevents any party to the contract create a law of limitation as well as the law of restriction of their. The court also noted the history.
My lord will kindly read second page, last sentence of the first subpara. Second page. Second. The High Court has rightly held that exception 3 deals with curtailment of the period for creditor to approach the court to enforce his rights and does not in any manner deal with claim period within which beneficiary is entitled to lodge his claim with the bank or guarantor. Last sentence of first subpara.
So basically, that exception 3 of section 28 is that ordinarily there cannot be any restriction
Yes, originally there.
to enforce the right before to enforce his right through legal proceedings in ordinary tribunals by curtailing the period. Right, that is what High Court has rightly held, that exception 3 deals with the curtailment of the period for the creditor to approach the court to enforce his right and does not in any manner deal with the claim period.
Within which?
So the claim period has not been dealt with. Then again, we come back to again that whether validity period and the claim period can be different or not. If this is so,
It is always in practice.
it is, but there has to be,
After claim period, there is a 1 year period.
what is this IBS circular?
That is not available with me today, Your Lord.
Huh?
That is not available with me. Huh?
Because there is an IBS circular 5 10 to 2023 and 5 to 2000. Get it.
Yes, sir.
In the meantime, we'll hear the other party. Get it by mail. So that if Bank Association, Indian Bank Association is a body, what kind of body?
think they're looking after the interest of the institutions, my lord.
No.
I think it's an
Like say,
association.
Chartered Accountant Association of India, that is a statutory body.
It's an association of juristic person, my lord.
Welfare, but no, the nature of the body,
I think they are registered societies, my lord.
society.
Normally, these are all societies under the societies registration.
Okay. The decisions, Sumac International. You have cited, Mr. Chaudhary?
Yes, my lord. Can I place that? Yes. Please come to my lord, paragraph 12.
Which one? UP State Sugar
Ye-
Corporation?
Yes, para 12. The law relating to invocation of such bank guarantee is by now well settled. When in course of commercial dealings, an unconditional bank guarantee is given or accepted, the beneficiary is entitled to realize such bank guarantee in terms thereof, irrespective of any pending disputes. The bank giving such a guarantee is bound to honor it as per the terms, irrespective of any dispute raised by its customer. The very purpose of giving such a guarantee would otherwise be defeated. The court should therefore be slow in granting an injunction to restrain realization of such bank guarantee. Now, this is important. The courts have carved out two exceptions. A fraud in connection with such a bank guarantee would vitiate the very foundation of such a bank guarantee. Hence, if there is such a fraud of which the beneficiary seeks to take advantage, he can be restrained from doing so. The second exception relates to cases where allowing encashment of the unconditional bank guarantee would result in irretrievable harm or injustice to one of the parties concerned. So these are the two exceptions carved out. Otherwise, the court should be very slow in interfering with an invocation of bank guarantee. Now, having regard to the legal principles, my lord, if your lordships will kindly have a look at the interim order which was passed by this honorable court, that is very important. The order dated, my lord, 8/11/23. I'll have your kind attention to page 3 of that order. Law, second subpara. Law is firmly settled that invocation of irrevocable bank guarantee cannot be injuncted by court except upon fulfillment of at least one of the two grounds, that is, practicing fraud and irretrievable damage to the parties. After going through the materials on record, this court is privacy of the opinion that none of the above conditions are fulfilled in the case. However, the larger question that confronts the court in this case is as to whether bank guarantee which have already expired can still be encashed at this point of time without extending the validity of the same. Merely on the basis of an agreement entered into by and between bank and the employer, wherein writ petitioner is not even a party. This is more so since particular clause in the bank guarantee relied upon by APDCL apparently runs counter to the terms and conditions reflected in communication dated 4/1/21, which makes bank guarantee valid only for a period of 22 months from the date of signing of the PPA. This court is therefore of the privacy opinion that there is a genuine controversy involved in this case, which should be required further consideration by this court. So court was oblivious of the fact, my lord, of the settled law. But in the facts of this case, my lord, court felt there is a larger issue to be gone into, which of course is slightly different from what we are confronted with today, my lord. Today we are, I think the actual matter is before the court. In that view of the matter, my lord, I think perhaps lordship is examining the matter.
Yes, because two exceptions already privacy
Yes.
observed.
The court was of the
Because
view that we would not have dealt with the matter, but
And
for the
it
other
is-
issue.
Because suppose fraud should be from the part of the beneficiary.
Yes.
It appears that bank at the time of issuance of the bank guarantee or taking delivery by the petitioner from the bank, there was no such act on the part. And secondly, irretrievable injury, they are APDCL backed by state. If you lose, it can be recovered. Yes, as an individual, there will be substantial damage. But it is not an irretrievable injury.
No, my
So
lord,
these two.
the moment something
But
can be
the
compensated.
issue is that whether a bank guarantee can have two periods.
Yes, one for enforcement, one for enforcement and other for claim.
One, no, if we go by this
From
exception
the
three,
perspective of the APDCL,
basically, section 28 exception 3 is regard of barring any party
restraint in the judicial proceeding.
judicial proceeding. Right, that is not directly applicable
No.
in the case in hand. Yes, it has some relevance. Bank can say that because we know that in case of guarantee, if it is the other party's government, then limitation period is 30 years. 30 years.
Private party 3 years.
3 years. That is why this has come in.
Yes.
Because bank will be in difficulty for 30 years. But here the question is not that. Here having two periods. I think
My
bank
lord-
was.
My lord, my humble understanding, especially after going through the 3 sentence from the document placed by my learned friend, my lord. Now, for the purpose for which APDCL would like to rely upon, that is not the purpose for which this can be used. This is only from the point of view of the, my lord, bank as a creditor, because when it comes to government, it is 30 years. When it is private party, it is 3 years. That's why it is 1 year. That's got nothing to do with the claim vis-a-vis the
No,
person.
but the wordings are different.
Huh.
Page 82,
Huh.
the bank
Yes.
guarantee,
Huh.
we cannot now directly read into it.
Yes.
Exception 3 to section 28.
Yes. Correct.
The words are in such manner.
Yes, 82, my lord.
Ah.
We are liable to pay the bank guarantee only and only if we receive from you at our address stated below a written
You means
claim,
APDCL.
demand or not later than 1 year from the said expiry date,
Now,
telling which all your rights under this guarantee shall extinguish and we shall stand completely discharged. Now, so far as my lord, invocation part is concerned vis-a-vis the person who has given, he may not be attracted also, my lord, strictly speaking. This is something which it is between bank and the APDCL. As far as your claim is concerned, you have to make within 1 year. Otherwise, beyond that, you don't hold us responsible. We have got no obligation beyond 1 year. Say that meaning also can be given. In any case, my lord, it's an understanding between the bank and the APDCL to which I was not even we didn't have any privity of contract. Therefore, to my lord, invoke this against us. It will be, my lord, onerous. It would be unjust and unfair.
right, we are considering that aspect
Yes,
also,
yes.
but it appears prima facie there is no hand.
And my lord,
There is no hand of the APDCL also.
yes, yes, yes,
It is not that they have a hand.
yes. I think, my
Even if
lord,
we find a small semblance of their hand in incorporating, then yes, it will be behind your back.
yes,
But it is not their handiwork also. It appears to be a
a
clear
handiwork of the bank.
bank. That is what is confronting the,
my
and
lord.
bank is not answering.
My lord, some understanding reads in the Indian Bank Association's, meeting, or that cannot govern the legal relationship, my lord. End
Yes,
of
that
the
is
day,
also,
if they are pleading 28(3), then lordship will deal with it.
No, that is why.
Ah.
What kind of entity IBA is? Because suppose
No, I don't think, my lord,
a directive is issued by RBI,
Ah.
Reserve Bank of India, to all the banks.
Understandable.
Incorporate this claim period of 1 year.
Ah.
That is binding for all.
Yes. But it has no
There is no
statutory-
doubt about it.
It has got no statutory force, my lord.
That is why I asked the question, what kind of entity IBA is? If this has been incorporated at the instance of some directive or advisory issued by the
Or even by
IBA.
the finance ministry also, then also it may work. In any case, it being a banking related matter, my lord, under the Banking Regulation Act, it is the Reserve Bank of India.
That is what. But still not having any answer from anybody. Yes, Mr. Pathak can have.
Before my learned friend stands up, if we read the three clauses in page 81, my lord, if we read it harmoniously also, what I am submitting will perhaps flow. Can we digress from this two? This bank guarantee shall be valid up to 24/1/23. Are we not supposed to give a meaning to this also, my lord? So as far as the validity of the bank guarantee is concerned, who are the person applicant, it is valid up to 24/1/23. So this meaning we cannot digress when you try to understand what is the meaning of three. When it comes to, my lord, empowering the bank to enforce it or bank to discharge its liability. So each of the clauses has to be given a meaning. And when we
No,
do so,
otherwise, clause 1, 2, 3, 4, there is no doubt about it, that
Yes.
it is an unconditional, irrevocable
part of it,
bank,
it's a bank guarantee.
guarantee.
Yes.
But whether it is only will stop at 24/1/2023,
Ah.
or it can go beyond
No, my lord. No, my lord.
on
I
the
think there is-
ground of
there-
some.
No, there is one more, perhaps one more angle to it. 24/3/23, 24/1/23, it will bind whom? All the parties, or the, my lord, the applicant and the APDCL. And beyond that, my lord, it is between whom will you, my lord, this three is to, apply to whom? We are liable to pay the bank guarantee only and only if we receive from you at our address stated written claim. That means, my lord, the bank is telling APDCL, if you want to enforce this, please write to us within 1 year. Literal meaning, man. Failing which all your rights, that means right of APDCL. When they are dealing with rights of APDCL, how can they deal with our right, my lord? So I don't think, my lord, 28(3) will come to the rescue of even the bank.
23 is
It's a different context.
different platform.
Anyway, my lord, the understanding of Indian Banking Association officers, they perhaps, my lord, well, if it is consistent with the legal principles,
Banking
then
norms.
it's a different thing.
One judgment you have relied on this one.
Yes.
Or any other?
No, my lord, I'm relying only on this.
Yes, Mr. Pathak, you can have a reply. Can you throw some light? Mr. Sharma has not been able to throw light regarding validity period and claim period.
Firstly, regarding the Delhi High Court judgment, which is the foundation of the communication of the IPA, I went to the judgment 50 years ago, after 14 years. There the issue was, your lordship, that prior to issuance of the bank guarantee, because the bank guarantee was in a different format and this clause regarding an extended claim period was not there, the bank wrote to the contractor that unless you incorporate this clause, since that is apparently the mandate of, that was the understanding of the bank, that is the mandate of the exception to section 28(3), we cannot issue that bank guarantee. In those circumstances, that petitioner approached the honorable court saying that this is the fiduciary understanding and 28(3) would not have any application, therefore bank guarantee has to be issued. In those circumstances,
I think who is the party there? L&T
Punjab National
versus
Larsen and Toubro. L&T.
what happened? L&T is a large conglomerate. MNC, they undertake construction works everywhere, all over the world. They may be having 1,000 projects. Everywhere they have to give bank guarantees. And banks started incorporating this 1 year period of claim period. So they have to maintain all this extra deposit to
For each and every.
keep alive all these bank guarantees. They had suffered for that.
Probably. That might.
If they go on this year 50 projects, next year 200 projects, but they have to keep alive all these bank guarantees all over the world.
Perhaps that might.
And they say that why this 1 year?
Where has this come from?
Where has from come? Their bank said, no, this section exception 3,
That is-
section 28. Then
Delhi High Court is
in that context, High Court has held
that cannot be the foundation of this. So that definitely, but here what has happened, the actual position is that when the bank incorporated this clause by amending the schedule 3, the power purchase agreement. The petitioner did not object at that point. Instead, he submitted that bank guarantee to us, saying this is the bank guarantee issued by the bank. The claim period is X and the validity period is X and the claim period is X plus 12. So that is the bank guarantee with us now. The bank guarantee issued by the bank submitted by the petitioner to us. Now the petitioner has himself said that this is a project which I cannot continue. For what this is the reason I could not procure the land, so I cannot continue this project. So we have no option but to encash the bank guarantee, invoke the bank guarantee. In terms with the bank guarantee submitted by the petitioner, there is no other guarantee. So logic presently for us, there is consensus item between the bank and the APDC. Bank has said that yes, we have incorporated clause. They may not have been entitled to, or they may be entitled to. The fact is that that clause is there, and that bank guarantee was submitted to us by the petitioner, which we have invoked within the time frame given in the agreement. Now, since the petitioner is a stranger to the agreement, he might have a very valid ground that yes, I was only obliged to give a guarantee for 22 months. Where did this extra 12 months come from? So he might very well have a claim against the bank or the bank against him. But the agreement per se, your lordship, that remains a valid agreement executed by the bank and submitted to us. Now, can that agreement be injuncted on a prayer made by the petitioner, your lordship, when both the two exceptions, your lordship, of fraud and mutual damage are absent? Well, that would have to be considered.
That issue is not
Yes.
here. That fraud and two
Yes.
exceptions are not here.
They are not here. They are not.
Here the question is how this claim period has got incorporated in the bank guarantee,
Bank guarantee.
by virtue of which it appears that another 1 year has been given to the beneficiary to claim the amount under the bank guarantee
claim
beyond the validity
Beyond
period.
the validity.
Right.
Yes. Yes.
If suppose bank is not filing any affidavit, if the bank comes up with a plea that that incorporation is relatable to exception 3 to section 28, in that case, you have to come up with a plea that this we have not asked for, like L&T. No. That is because by that clause, if they come up with a plea that this has been incorporated because of exception 28, that was also not add item to in conformity, in consonance or taking consent from you.
Yes.
But otherwise, if it is relatable to this exception, is this last sentence is relatable to exception 3 to section 28, then you are barred from enforcing your legal right after expiry of 1 year.
If that is the reading of the bank. Yes.
Right.
Yes.
Then you have to challenge. Right? No, there are various pros and cons. If they come up with a plea that this is relatable to clearly this enforcement of legal proceeding, and we have barred the APDCL to enforce their legal process
Beyond 1 year.
beyond 1 year, then after 24,
If bank says comes up.
they are not coming up.
That this clause only refers to initiation of proceedings and not to invocation. If that is the.
Though, from a reading,
Yes.
it does not
It does not,
emerge.
yes, it does not. If that is, if the bank comes and says that no, by invocation we only mean initiation of legal proceedings, then that will definitely be under section 28, section 28. That is perhaps not the case.
When the case was initiated,
The bank guarantee was.
no, initial order, because bank is an important party.
Yes.
November, they have not filed any affidavits.
No.
Huh?
My lord, first day, nobody appeared from the bank, so therefore we have taken steps.
Something wrong in the initial order.
Huh?
Because
I have.
no notice to. Mr. Pathak, bank is party or not? It has been recorded that Mr. Pathak has accepted notice on behalf of all the respondents. We also cannot. Court has recorded that Mr. Pathak has appeared for all the respondents, including Federal Bank.
Furnish a copy today itself. Huh?
No, issue is not there. If we cannot record now, that
Followed by that.
you can say so, but it is very difficult on our part now.
Correct.
I understand that the stand of the bank is very important. So let the bank file an affidavit by Monday. Let the matter be taken up on the 23rd for final decision. Tuesday, let it be taken up with the first time. So 24th, we are facing the deadline. After that, everything becomes instruction. They can file it by Monday. Perhaps my friend will have to do some. When the midnight or so.
Service of notice
Now it is completed.
will be difficult.
Difficult.
Either this way or that way.
No, my lord. In the
If
event,
it goes in your favor or goes
my
in
lord,
favor of
in
Mr. Pathak,
in any
that
case,
will be a clear ground that for appeal.
no. So what I'm saying is, my lord, even to supposing my lord, eventually lordship finds we do not have any case. Lordship can always extend that.
Which one?
There to protect their right. Lordship can pass an appropriate order.
We have also filed an IA in that. That is
We thought of,
disposing today.
that is why I found that whether notices are served or not. Now he has come up with a plea.
তুমি আগতে ক'ব লাগে কিয় কোৱা নাই মই দি দিলো না copy.
You are not saying anything. The matter is being taken up everywhere. Notice is accepted by somebody else. And also,
No. If you would have indicated, you would have given a copy, my lord. Anyway, there was
some difficulty.
my learned friend can file the affidavit by Monday.
Ah.
Then
We'll record that Mr. Sharma has received a copy of the writ petition. RFP copy will be supplied to you by Mr. Patwari
today itself.
today itself. We keep it on Monday. You just explain this. Factual part you do not have to explain. Only the last line in the bank guarantee, wherefrom you have incorporated it.
Is there any statutory background?
There.
and what is the understanding of that
Clause.
clause?
Also understand whether it is relatable to exception 3 to section 28 or the claim period.
The claim.
If the claim period is there, it is Mr. Pathak. If it is relatable to exception 3 to section 28, it is Mr. Chaudhary. Prima facie.
Yes.
Without reaching any final
yes,
view.
yes.
So it is up to you. And that has to be backed by some region or enabling provision somewhere. Otherwise, there could be a situation, Mr. Pathak, Chaudhary, he might not be available,
My lord,
might not be available,
Monday,
maybe, or
my
Tuesday.
learned friend would be there, my
No,
lord.
there could be a situation.
Uh-huh.
If we could not dispose of in a
Yeah.
particular situation.
Yes.
We don't know about.
No, lordship will
No,
make
this suppose, I'm just visualizing a situation. It could happen that because of certain more clarification, because we are not very much conversant with banking parlance.
And Monday could be a holiday also, my lord. You never know.
In extreme situation arrives, Then whether there can be a situation of extension of the bank
No,
guarantee
that-
subject to.
So there, my humble submission would be, my lord, lordship
So
will
that-
make an observation. Depending on the outcome of the case, lordship will pass appropriate orders.
Petitioner should take appropriate steps for extension of the bank guarantee.
Ah.
Bank guarantee, but that would be subject to the outcome.
Yes.
But it will not have any enforceable right to the APDC. Just for the purpose of keeping it alive. Either way, otherwise, on Monday or Tuesday, I have to decide one way or other.
Or in that case, can I put it this way, my lord?
Yes, please.
We'll apply for 1 month. Lordship will have it on February 10, 12, 15, any day.
Without any enforceable
Yes.
right.
Only for a
Because
period of 1 month.
That 1 month will be dependent upon the validity period, claim period, and
Everything will depend upon what final order lordship passes.
everything will depend upon what exists as on 24/1/2023.
And what meaning lordship gives to that, maybe on a later date.
That could be a situation. So we'll find out. Just take instruction from your client. Otherwise,
Let it come up on Monday, my
it
lord.
may amount to a big amount, right?
Yes, yes.
How many? 4 crores.
4 crore 20 lakhs.
Mr. Sharma, you try to file the affidavit, short affidavit by Monday. If it is not filed, they will take up in the second half, after the motion matters. Heard Mr. Kenchuri. Because this is a case which is not covered by any of the 100 judgments of the Supreme Court.
Very peculiar.
Apart
Very
from the
good.
Delhi High Court judgment, apart from that, I could not find anything.
I had Mr. Kenchuri, and senior counsel stayed by Mr. J. Patwari, and counsel for the petition. Yeah, look, গরম লাগছে, গরম হয়েছে। Mr. Devi Bharat, Land Standing Counsel, PDCL for the respondent number 1 to 4, and Mr. M. Sharma, Land Counsel for the respondent Federal Banks. Within bracket, respondent number 5. Mr. Sharma, Land Counsel for the respondent bank, has submitted that as he has been furnished with copies of all the pleadings. Mr. Pathak, no, in the, you need anything, please tell me.
RFP to কি है?
A request for proposal. NIT.
Oh, other
NIT.
than only NIT. Yeah, by different name it is known. RFP.
RFP.
No, but different names are there, my lord.
He has been
RFP খন এইখন।
furnished with,
এইখন।
okay. He has not been supplied with a copy of the request for proposal RFP. So he has further submitted that if the copy of the RFP is supplied to him during the course of the day, he will make endeavor to file the affidavit on behalf of the bank as regards incorporation of the clause in the 3 bank guarantees, which reads as under, page 82, Roman clause 3 as we are liable to pay. Full stop. As agreed to by the Land Council for the parties, please the case on Monday. With the expectation that if it is not holiday, we will take up in the second half.
Sound hold also connected. 65.
লগাই দিব, order to লগাই দিব, 65 to লগাই দিব. Then otherwise, if it somehow it could not be proceeded with, then Mr. Patwari will obtain instruction as regard survival of the bank guarantee for a further period of 1 month.
Number 26.
Or interim order passed, I shall continue till the next listening. Some
Fine.
interim order.
Yes.
May I please, as your lordship? My lord, I'm very sorry, my lord, this is the third time the matter has been listed.
What can we do?
My lord, my lord, the issue which has been raised in the writ petition, my lord, is purely regarding the civil dispute, my lord, regarding tussle between two institutions. One, my lord, upper primary school and one Anganwadi center. They
Then
are,
we can take up on a hearing date
my lord.
immediately.
Yes, my lord.
Maybe state government also find they have to give,
No, if they are not filing, my lord, on our IA can be disposed of, my lord.
Okay, very good. Say expected time. Next week.
My lord, a hearing day may kindly be fixed, my lord.
6th of February. 6th of February.
My lord, can it be next week?
Right. Many cases
My
have been
lord,
fixed.
my lord, what has happened, my lord, a Anganwadi center, my lord, has been hold from construction, my lord. That's the problem.
We also understand what is of most emergency, what is not of most emergency.
My lord.
Seeing the nature of the case,
My lord.
it does not fall in the first category.
My lord, we have.
AR Bhuiya
My lord.
for the applicant. IAC number so DP Solial and senior counsel for the opposite party petition. MS Borman, learned junior government advocate. Assam appealing for a state respondents has submitted that counter affidavit in the connected repetition would be filed within a week's time. As agreed to by the learned counsel for the parties, released the case on 6/2/2023 for 24. An endeavor will be made on the said date for final consideration or
My lord,
petition.
it will come in the order stay vacating column, my lord. Because petition is pending, my lord.
No, it will come.
My lord.
One matter by of, eviction matter.
Eviction matter.
What also miss?
Yes, learned counsel. Is there any matter where interim order is still today?
In all cases.
No. It will to interim order continue for you. In any of the other cases, repetition. Causes. Interim order is still today. Which item?
Item number 64.
Mr. Soikia, just 64. Okay. Ardeka, huh? And who is for Canara Bank? Any counsel is there? Okay, interim order extend for you.
Item number 56, my lord.
Interim order is there.
Man, till today.
56. Okay, 56. Oblige.
For respondent number 123, in item number 54.
Okay, Mr. Your name, please.
Yes, Prabha.
Yes, Raval, petitioner. MS.
And that's for Mr. Karan Khadir.
MDAS for response number 3. Paucity of time লিখে দিব extension করে দিব
Lordship, item number 52.
Yes. Any interim order?
Yes, Lord.
Okay. F. Begum Talukdar is available. Talukdar
52.
standing counsel so and so cooperation. Paucity of time extension. Interim order.
Lordships, item number 46, interim is interim order is there, that is till today. And I am praying for fixing the matter on 8th of February, Lordships, a very urgent in.
B. Hazarika 45.
45.
F.U. Barbhuiya 46. S.K. Talukdar standing counsel cooperation for the state respondents. Paucity of time. Data sabo. Interim order passed earlier shall continue.
I'm praying for taking up the matter on 8th of February, Lordship. The urgency is there because after election.
9 of February.
9th of February. Oblige.
Made to your lordship. Item number 48. This matter relates to the sealing of the campus of the petitioners NGO for last about 1 year. It is under sealing, your lordship. But unfortunately, the matter
Okay, seventh. Seven,
Lordship, next week, your Lordship. any day.
seven.
It will be, because for
Seven.
last 1 year, it is under ceiling.
Seventh. Yes,
May I please, your Lordship, item supplementary 63, interim kindly be continued.
63.
Yes. Supply 63.
Sile over. 63. Paucity of time, interim, continue.
Item number 39, any short date may be given.
The interim is there or not?
No interim. Lordship.
Otherwise, you persuade the court master. Yes, Mr. Sai.
Held on the earlier occasion, my lord, on 9/1/2024. The notice is at page, my lord, 101.
10.
One is the vernacular, my lord. 100 is the translated.
101.
This has been pasted in the, my lord, village of the petitioner. There is no date, my lord. No particulars of the, my lord, land. No date of, my lord, event by which I have to, my lord, leave, my lord.
There is a suo motu PI, my lord, wherein my directions of past, my lord, to conduct evictions in eviction in Gwalpara. And also, my lord, in that same PI.
Suo motu PL.
Yes, sir. Based on letter petition, considering my lord, Gwalpara and it's, my lord, there's a high density of my lord enforcement and also my lord, human element conflict. Today, while.
Forest areas.
Yes, these are all forest areas. And they are in their proceedings, my lord, we are also facing so much of contempt, my lord. Wherein the attention of the past to my lord, to make sure, my lord, we take effective direction, effective steps to carry out evictions. I'm passing this orders.
This, my lord, the direction has to be as per law, my lord.
Therefore, my lord, to satisfy this court, my lord, they have bought in some sale deeds. Those sale deeds also, my lord, doesn't reflect. Only the schedule of land is not there. Only 10% part is there. Somebody has sold this to that. And that part also, my lord, there is no whisper. That are the land rights they have, my lord. And my lord, there are 88 others, 86 others.
Is there immediate threat, Mr.
Yes,
Sai?
yes, my 17 they have pasted the notice in our village. There is no 17/1, my lord, and I have to, verbally they have said by within 2 days you vacate. Otherwise, they'll, my lord, evict us.
Mr. Gogoi, are you in a hurry? Or you can wait till Monday?
So, wait, but my lord,
Till Monday.
fortunately, this matter didn't come up on 18. Otherwise, we would have to have filed on, my lord, see that order sheet I have passed, given order sheet passed with PI and so motor. We have to file a comprehensive affidavit, my lord, to, as regards steps taken of complying the eviction, my lord.
This is suo motu. It was order is passed on when?
There are two orders, my lord.
One is 5/9/2022.
So, my lord, that is connected to the PL store, content so
Suo motu.
motor.
PL suo motu, yes, that is 5/9/2022.
Yes, 5/9/22.
Okay, there is another order.
The leading page is W Bismarck, but it is connected with
What happened on 18?
18, my lord, the matter was not listed, but by 18 we had to, so my lord, the evictions are now conducted and we have to file an affidavit, my lord. Otherwise, you are facing them, which is there also. My lord, you see that order dated 19th to 2023. Kumar Khali already specifically mentioned that Lakhipur range. These are all, my lord, the eviction, you will see, my lord, will see, these are all as regards Kumar Khali reserve forest.
You don't have anything.
There is nothing to substantiate, apart from that, they have some right has been created as by Anganwadi centers, our Yojana, they don't have a land document. Something should have been there.
What land documents? Otherwise, Mr. Swagia?
Madam, these are.
Nandita, my lord,
One minute. What are the documents? Otherwise,
To cut short, but I have shown the because Lordship has dealt with this matter in the earlier occasion on 9.
Mr. Gogoi,
Similar
can
notice.
you wait up to Monday as a motion item? Because I will have a meeting also.
We are,
Don't-
I'm not
If you
talking
take
about-
a vote, otherwise we will record, no coercive action. No eviction shall be take place till Monday.
Can you take note of that also? Otherwise, my lord, again,
Which one?
suo moto contempt and my lord, suo moto. orders.
These orders cannot mean, my lord, illegally or without following any rule, they will issue. my
This is the
lord.
point issue, my
My
lord.
lord.
I'm ready to argue this point because if
Yes.
they have, somebody has to show what right they have to ensure that they are, that process is followed.
And I am
But they
questioning
have
under
to
what
show-
authority you have issued the notice? For which land?
No, otherwise, Mr. Hoikia, if it is a declared forest
Lordship.
under the Assam Forest Regulation or
Yes.
Indian Forest
Yes.
Act, either under section 4 or section 5
Lordship.
of the acts, no rights accrues to any of the petitioner if it is within the declared forest.
See, now my lord will.
And that has been repeatedly, because if it is forest
Forest.
and declared
Yes.
reserve forest,
Exactly.
if it, I think these forests are perhaps declared.
Declared forest, my lord.
My lord, I have made a statement in paragraph 4 that the petitioner gradually constructed their houses on the present plot of land without any obstruction from any authority. It is pertinent to mention here that in the year 1985, the range officer demarcated forest area and erected wire fencing. According to the site, said
No,
fencing,
if
the
the
petitioner's house was
notification
for-
is there in
outside the
1950
forest
or
area.
1960, that is enough. Even if the provisional or draft notification.
Look, let them show, my lord, that's what my lord, we are saying, because.
Okay, we get then we'll decide the entire thing that day.
Monday. And
But
what
don't-
the court fee issue I will bring up, man.
Huh?
Court fee issue I will bring up. HVC others.
Okay, okay. Heard Mr. PJ Hoikia, Honorary Council for the petitioners. And
I have no issue with that.
Mr. D. Gogoi.
Purpose is something
The
else, not
Standing
for
Council,
eviction.
Environment Forest Department for the respondent number 1 to 3. 1 to 3 and 5. MSM Burma. Junior Government Advocate Assam for the respondent number 4. Close stop. Apprehending eviction from the plots of land under their respective occupation pursuant to issuance of a notice, annexed as annexure 14 to the writ petition by the respondent number. Who?
DF.
Respondent number 3. The petitioners have approached this court by the instant writ petition. Full stop. Mr. Gogoi, the Standing Council Forest Department has submitted that the petitioners are in occupation of lands falling within reserve forests.
No, my lord, we are saying we are my lord, occupying land in Kusai Pakri, part 2.
No.
That's-
Kumarkhali Reserve Forest, a forest declared under the Assam Forest Regulation 1897. Will you be in a position to get the notification? And he will be in a position to place the concerned notification by Monday. So, as the dispute is regarding the location of the land is also in question, let the case be listed in the motion column on Monday. Till then, no action shall be taken pursuant to the notice, impugn notice within bracket annex 14.
my lord, they may also place, my lord, the provisions of law under which they have the authority to issue that notice. But that, my lord, it is-
No, then if they can show by producing the gazette notification issued under section 5,
Yes.
then onus will shift to you to show that how you have come in occupation of
These
because of
details I have
settled
given.
position of law.
Details I have. given.
House structure we are not concerned with. If he comes up with a notification that this is the coordinates within this, these petitioners are situated, then onus will shift to you. Then we'll examine your writ petition. Today I am protecting it. Today, as on today, I am protecting you that there shall be a eviction pursuant to that notice. Till Monday, you have that. We are not issuing notice of motion, isn't it? We'll find out. You can remand that.
Yes, but
You have-
my whole thing is under what provision or what authority you are doing that?
No. Then if he comes up with that notification, then no authority is required. Law is settled. Inside forest land, if both of you do not come up, I'll come up. With all the judgments. I remember.